intend to do two or three things. I will not necessarily address all the arguments on the other side, but only those which are relevant for my propositions. Apart from that, I'm ready and willing to answer any questions that might fall from this court. So, my lord, let me straight away tell you how I propose to proceed with these arguments before I actually make them. The first argument I wish to make is, how does one read a constitutional text? We are not reading a statute. We are reading a constitutional text. So what has this court said about that? What is the law declared by this court on the way to read a constitutional text, which obviously I will say it's substantially different from how you read a statute. A statute may be read in a semantic manner, but not a constitutional text. And I will give my reasons for that. That's the first point. Secondly, my lord, I do wish to confine my arguments to the right which is claimed by the people I'm representing. I do not, because the reason being, my lord, it is a little difficult to answer abstract questions. It's best to answer them in the context of a right which is being claimed. And therefore, I will confine my submissions only to the right of temple entry. This is going to be the sum and substance of my submissions. My lord, the third thing that I will present to you is what is the triangulation of the different provisions in the Constitution of India. How does one square them and read them as an organic whole without splitting? In other words, Lord, it has been done by this court in Maneka Gandhi, etc. But I choose to call it a kind of a triangle, for want of a better word. It's just a way of conveying an idea that there is an organic way of looking at the Constitution as a whole. This will be one of my submissions. And my lord, I propose to collapse all the 7 questions into one single question, which in my opinion, will cover everything except, of course, locus standi. I will deal with that a little separately. But the substantive questions, 1 to 6, I intend, my lord, to say that this court will not recognize any practice anywhere, whether in a denomination or individually, in 25 or 26, which violates any of the provisions of Article 15 on the prohibited categories. It is not entitled to recognition by a court of law. That is going to be my submission. And that is, I will have to make it good. And that, I believe, will answer all the 6 questions. Of course, the locus standi question remains to be addressed, which I will address. Now, my lord, having said this, what I want to point out to you is, who am I representing? Okay. Lord, after the Sabarimala judgment was delivered, and your lordship may kindly make a note of one fact. This court has not stayed the Sabarimala judgment till today. Please make a note of that. It remains in full force and effect. As and when the review petitions are heard, my lord, the question will arise whether it's to be overruled. But as of today, no court of law has stayed that judgment, not even the 7-judge bench, not the 9-judge bench. Only questions have been referred, arguments for presentation to the court. So therefore, my lord, if I wish to, I'm entitled to rely on the questions of law which arose in that. However, I'll try to avoid that also. I'll try to make an independent argument, not necessarily.
That's better, because they'll also would rely.
I will, my lord. It's only a matter of fact I want you to keep in mind. That's all, because it concerns the people I'm representing. Now I come to the issue. Who am I representing? I'm representing 2 women. One of them is scheduled caste. So I will ask the question: when you keep a scheduled caste woman out of visiting the temple, are you violating Article 17 or not? She's a Hindu and scheduled caste. So I will ask this question, my lord. Is the abolition of untouchability only for men, or does it include all persons? Today we are told that yes, non-caste Hindus can enter Sabarimala, but not non-caste women. That is the proposition before you. We are not being allowed to enter. All men can enter, no restriction of caste. Why? Because of Article 17. That's why they can enter. But I happen to be a scheduled caste woman.
No, you are not prevented because you are a scheduled caste woman,
Exactly.
but because you belong to the 10 to 50 group.
Yes, I will answer that at the right time. I know that. I know that.
Indira Jaising, in any lady above 50 years is also permitted. They are not-
Yes, yes. But of course, I will deal with that at the appropriate stage. Obviously, my answer is going to be the most productive and creative period of my life. That is 10 to 50. What is a woman's status between 10 to 50? It's a status. It is a status. During this period, she's most creative, she's most fertile. Never mind, menstruation, will come to that later. You can't tell me live half a life. Avoid living between 10 and 50. Avoid enforcing your life between 10 to 50. Enforce it before 10, enforce it after 50. That will hit substantial deprivation within the meaning of Shururmat. That is going to be my submission. Shururmat said you cannot substantially decrease a person's right. Is this substantial or is it not substantial? That's the first question. Second, Devaru, my mistake, Devaru. Devaru, in the process of harmonization, they said substantial injury you cannot make to a person's right under 25(1). So you will have to answer the question, is this or is it not a substantial injury? And my next submission is going to be, any violation of equality is a substantial deprivation of the right under 25(1). Very clearly. Any denial of equality is substantial injury within the meaning of 25(1). You have to decide the question, Manoj, since you're sitting in a group of 9. Is equality a basic feature of the Constitution or not? And if it is, what does it mean? Will you use the provisions of Part 3 to interpret the width, breadth, and content of my right under 25(1)? My argument is, I'm being denied my right under 25(1). Now, my lord, let me proceed further. What happened is, after the judgment was declared, these two women went to Sabarimala for darshan. For want of a better word, in English you would call it worship. They went. When they came out, the Tantri did a shuddhikaran. I filed a petition in this court. Mind you, this is when the judgment was in full force and effect. I went. These are the only two women who succeeded in climbing up and doing darshan. No one else has succeeded since then. Why? Because the state has not cooperated with us. They refused to give protection for going up. I filed a petition in this court, and in which I put all these facts on record.
Are they devotees and from which state they are?
Kerala. They are both from Kerala. One's name is Bindu, the other person's name is Kanaka Durga. Both are Hindus.
They are
So, my lord,
not
what happened to that petition I filed? I want to.
attempted to go to the temple prior to the judgment.
No.
Are they devotees or not?
I beg you, let me tell you the facts before I answer that question. As far as Bindu is concerned, she has been taken to the temple by her mother. That is her statement in a petition filed in this court. When she was age 11, she's already been there. After that, this judgment came. After the judgment, only once she has succeeded in going there. Not twice, not thrice, not 4 times. She was mob lynched for having gone there. At Kanaka Durga, I believe she had problems with her family members. Her family also kind of came down heavily on her that why did you do this, etc. But as far as first petitioner is concerned, she was left free by her family to go according to her conscience. But after that, she has not succeeded in going there. In fact, to be honest with you, she has had to migrate out of Kerala. Never mind, that's just a little fact I wanted to let you know. But at the present moment, she cannot live in Kerala anymore. And actually, once she had approached me and told me she's going to migrate out of the country. I said, no, don't do that. Come to Delhi, do what you want to do, but don't migrate out of the country. She's also happens to be a lawyer. And
Why do you say it softly?
because she went in her capacity as a, because, my lord, never mind. It's, I want to tell you just a small little
Nothing
story.
wrong in it, as Mr. Sir put it, lawyer is a social engineer, social reformer. Obviously, she has done her part as a lawyer also.
Yes, because I did not want to say she went there because she's a lawyer. She went there because her conscience told her to go there. That's the point I'm making. Anyway, my lord, never mind, my lord, it's a very emotional issue, what she's doing and what she's not doing. But I want to tell you just a small story to lighten the mood a little bit. Mr. Abhishek Singhvi was sitting next to me. He said he was going to give me an award. I said, why do you want to give me an award? He said, for not interfering with anybody's arguments. I said, yes, I did not interfere with anybody's arguments despite grave and sudden provocation. So, my lord, as soon as this hearing is over, I'm going to claim my award from him. My lord, I think that the facts of this case that I'm presenting before you are very significant for the outcome of.
We are expecting the other side also to compete for that very award.
My lord, I said it was provocation,
There
but
are-
never mind.
there are- it may-
Although grave and sudden provocation is a defense, my lord. But never mind about that. I kept my mouth shut like a dormouse. But
Don't say sudden, you can say sustained.
anyway, my lord, to come back to the propositions. So, my lord, what is it that this court has, one more light piece of factual information before I proceed. My lord, the Constituent Assembly debated Article 25 and 26 for a total sum of 4 days. That's all. We are now in our 10th day. So, my lord, really, we seem to be sitting here as a Constituent Assembly. To me, it looks like that. We're sitting here to complete the job which the Constituent Assembly left incomplete. Supposedly, because of my learned friends, 55 counsel on the other side are telling you that they didn't do their job. Okay. Secondly, they are asking you to overrule both Shurur Math and Devaru. Now, first of all, sitting in this reference, you cannot overrule any judgment. Let me make it very clear. A judgment of a court can be overruled in accordance with procedure prescribed by law. And the procedure prescribed by law is review, curative, and show the per incurium in it. To the best of my knowledge, no one has been able to say these judgments are per incurium. No one used that word throughout these 10 days.
But this Jaising, we can definitely declare the law different from what is perceived to be the ratio of
Yes.
those judgments.
What will
We
be?
won't decide the case and
Yes.
overrule the result.
Yes.
But we can declare the law at variance to what is understood.
Yes, my lord, I don't dispute your jurisdiction. I don't dispute your jurisdiction, but I will dispute the binding effect of that. I will. I will dispute that.
Definitely.
It will be an opinion.
There's a distinction between the binding effect of a ratio and the conclusion binding parties by way of res judicata. We are not going
We're not res
serve
judicata.
any, but we can always interpret the interplay of 25,
Yes.
26, and the impact of the triangular rights
Yes.
in relation to the freedom of religion
Yes.
in a manner
Which is different.
from what
Yes.
Paru understood or what Sheshamal understood in
Yes, my lord.
Vacharaka.
I agree with that respectfully. However, I will dispute the binding value of that because you have not taken this decision in a cause which came before you. I use the word cause, I'm taking it from Article 145 of the Constitution of India, where you have to constitute a bench of 5 judges in a cause. And Justice Nagaratna has been reminding me again and again, how do you bring an issue to court? You bring an issue when you have a cause of action. This bench doesn't have a cause of action.
What you are reopening now has already been decided by the bench presided by the former Chief Justice as to whether a decision on Article 142 can be independently referred in terms of the rules of the Supreme
that-
Court rules.
My lord, I
Now,
agree.
that is a hiatus to the form in which reference is made.
I-
Once the reference form has been decided,
Yeah.
we will decide the reference on substance, that
Yes.
is merits.
Well, Lord, I will address you on substance and merit. I'm not running away from that. And my question is only what is the nature of the opinion that you will deliver? Is it going to bind pending proceedings in this court? That's the issue. I would like that question to be answered. And in my opinion,
The pending proceedings later on will be decided in juxtaposition to the law that we would be declaring.
What is the effect of judgment?
yes, well, Lord, I agree. But what I'm saying, perhaps in answer to my lord, I'm saying that there can be no abstract answer to that. Well, Lord, I was told by one of my juniors that the challenge to the Karnataka Religious and Charitable Endowment Act hearing was completed before a bench presided over by Justice Narasimha. And I'm told that the judges have de-reserved that judgment, waiting for this outcome of this. Yes. Even that I'm not making any comment on it. It is their privilege to do what they want to do. They could have gone ahead and declared it. There would have been no violation of any provision of the Constitution. Maybe impropriety, that's a different issue altogether. It was left to their conscience to do what they wanted to do. But it doesn't answer the question, what is the binding character of an opinion that will be declared by a bench of 9 judges, notwithstanding pursuant to 142 on...
You can raise this after reference is ordered. Once we order decide the reference, then probably when a review comes, whatever the subject to order to be passed, you can raise it in that.
Well, maybe I'll have to raise it case to case when any case comes, but I am just warning, it's again a note of caution, nothing more than that. It's just to tell you that whatever you say in this case is going to decide not only the cases which are before you, but also the cases which are not before you. The anti-conversion law, my lord, is pending before a bench of 3 judges right now on a daily basis. It will conclude that issue. So there are many issues which you cannot anticipate, which will be covered by your opinion. And that is why I'm only sounding a note of caution. And we need not preempt all those issues. Obviously, I will address you on the merits. There's no question about it. I have to make good the submissions I have started with in my opening arguments. So, my lord, let me come back. It's only this. Only just keep it in the back of your mind that you're not only deciding Parsi women's entry, this Bindu's entry, or FGM. FGM is before you, which there's going to be no decision. Can you genetically mutilate a Muslim woman and say that it's part of the right to religion? Question is there before you. So these are not the only questions before you. There are also questions, you will have to deal with Article 21 in that case. And then there are also questions which are not before you. One example I gave you is anti-conversion. Some 20 petitions are pending in this court, all challenged. A question was raised by one of you, my lord. What about UCC? Will you be in a position to challenge it or not? And a very unsatisfactory, in my opinion, answer was given. You can do that, but you can't do this. That was the only answer given. That a specific question was raised. If Mr. Vaidyanathan's argument is correct, will this country be able to bring in a UCC? Answer is no, if you accept his arguments. Autonomy. Well, Lord, some of the council have been economical with the truth before you. They've argued one thing for one religion, another thing for another religion. I believe that all of us are amicus before you, and we need to be not holding a brief, but assisting you in how you can decide this question. But this is what has been going on for the last 10 days, and I can give you specific examples of how the same person's argument changed while dealing with one religion and another religion. Never mind, but keep it in mind while deciding. Somebody, I think it was Dhawan, who said 26 is about autonomy. Did he spell out what is the meaning of autonomy? Did he say that? Did he say whether an exercise of the right to autonomy, I can keep out a woman from a temple? No answer. Did not address the question. He did not address the question which is specifically before you. He put it vaguely under the question, I have autonomy. Hands off. That's it. So, my lord, I personally believe you may accept it, you may not accept it. I personally believe this litigation is surrogate litigation for some other outcome which is intended to be achieved by this opinion. That's my belief. Because it covers much more than these three issues, the arguments. So, my lord, having said that, I wish now to come back to why am I saying that at this point, my lord, your lordship can now turn to my written arguments. But this will be the trajectory of the argument. And my lord, all these issues, whether constitutional morality is a ground for striking down, they are bogies. Why? Because no court has struck down anything on the ground of constitutional morality. They have used it to interpret the content of 14, 15, 25, and 26. Not a single judgment they can point to, which actually uses constitutional morality to strike down a law. All right, don't call it constitutional morality, call it constitutional legitimacy. This court has used that expression also in another judgment. So, my lord, I don't want to address bogies. I want to address the substance of the matter. And the substance of the matter is whether Article 25(1) is subject to the right to equality. Whether they're bound in law, where any denomination is bound in law to respect equality or not. We must have a straight answer. It's illustrative of what is to come in the future. There will be many, many cases coming before you which will make this demand. People who come after me will be making this demand. The Catholic Church has allowed women to become priests. These are not new issues that I'm raising in this court. At the moment, I'm only raising the issue of entry into a temple for the purpose of worship. I make bold to say it is a fundamental right guaranteed to me under Article 25(1). This is my first submission. The right to enter a temple, a place of worship, is a right guaranteed under 25(1). That's why what is the width and breadth of Article 25? Let us know.
So are you then making a submission that irrespective of any age group I belong to,
Yes.
my entry being woman cannot be restricted?
Yes.
I may belonging to any age group.
The limitation was Hindu. In all the statutes, the limitation is Hindu.
Yes.
But in Sabarimala, they go further and they say we allow Muslims, we allow Christians, but not women, Hindu women. One step further. Of course, 10 to 50, but 10 to 15 is what my productive life is about. That's when I'm really fully alive.
But madam, if there is an intersectional exclusion, can you say that the exclusion is gender specific?
One. The answer to that is I'm claiming both my right to non-discrimination based on gender and my right to enter on behalf as being a secular. I'm claiming both rights.
You are not being prohibited to enter as a woman.
Now,
You are being prohibited to enter as a age band
yes,
amongst women.
yes,
So there is an intersectional exclusion.
yes,
And in
but
this
the law
situation-
addresses intersectional exclusions. It does. The law declared by this court addresses intersectional inclusions because they say we don't bother about your intention, we bother about the outcome. That is the law declared right from Maneka Gandhi, R.C. Cooper till today. Not a single court has differed with that. What is the outcome of it? The outcome of it is I'm excluded. I get excluded on both grounds and I'm claiming both rights.
Who is claiming this right? Is a devotee claiming the right or a non-devotee? At whose instance? A person who has nothing to do with this temple is somewhere in North India, this temple is in South India, is claiming a right of entry. That also has to be addressed.
I will address that also. Of course, my
Because
brief,
you rightly said it can't be in the abstract.
I will address that
Who's a
also.
devotee claiming a
I
right
will
of
address
entry
that.
or a non-devotee who has nothing to do with this?
I will address that also. But for the moment, I'm replying to this intersectional
At whose
intersection.
instance we have to answer it?
Yes, I will answer that. But at the moment, I'm answering the intersectional rights. There are many intersectional rights. That is why you read the Constitution as an organic whole. And you don't look at intention, you look at impact. This is what the law declared by this court is. And I don't need to carry coal to Newcastle. All of you have read these propositions. Yes, but that is it. That's where all the proportionality, etc., come in there. They come in when there's a clash of rights and when there is an intersectionality of
That
rights.
is where Devaru
Yes.
makes a proportional impact. That
Yes.
the fundamental religion, integral identity of the religion is not being eroded. At the same time, there is an expression of either Article 19, 21 or 14 rights.
Yes.
In this situation, although we are not deciding Sabarimala, but let us say an example of this nature where 26 definitely trumps 25. It would be required for the court to examine whether 26 is of such exclusionary nature that it completely dims out 14, 19 or 21.
Yes, your lordship will decide that
It
issue.
an harmonious blend.
Yes, that issue will have to be decided.
26 be followed out,
Yes,
as has been held in Saidna and others. You
Well,
cannot hollow out a belief, irrespective of its nature of constitutional tests. We need not go into a constitutional test as to how a religion or a denomination will manage its affairs. And in doing that, it's the denomination A. We have to, in these facts,
yes.
decide whether
I
it
want
is
to
a
make something
denomination
very-
or not,
Yes, my lord.
has a certain set of rules.
Yes. Well, I want to make one thing very clear.
One thing, is it your then submission that this intersectional exclusion itself is impermissible either rationally or constitutionally?
Yes, it is. It is. It is my submission. And, but I want to make something I wanted to say. I want to make it very clear. I'm supporting Shururmat. It's rightly decided. I'm supporting Devaru. It's been rightly decided. There is no way you can get out of these two judgments if you want to balance rights. If you don't want to balance rights, if you want one to trump the other, go ahead and do it. Then decide which one trumps which one. But these judgments are giving you, these are the only, where is that? He told me, my lord, there is Justice Mukherjee here somewhere. Yeah. I was talking to Jaideep Gupta, who has changed his stand after the new government or whatever election. We are waiting for election results. But never mind, my lord. He is the one who pointed out to me that this worthy man is looking at you,
He's watching it.
watching what's going on in this court.
Also Justice Gajendra Gadkar. Don't forget him.
Yes. Yeah, well, much has been said about.
Some of them are invisible, but our belief is that they are also looking towards us.
Yes, yes. But the fact remains, jokes apart, the facts remain that his is the only authoritative text today. The Tagore law lectures, if you can get me a better one, I'm willing to jettison this. But the Tagore law lectures on the law relating to Hindu and religious and charitable endowments, there's no better book in the country today. So, my lord, before deciding this case, kindly send for the book from your library and have a look at it.
And
Because we're,
and Ms. Jaising, you would definitely be knowing an American judge, Justice Douglas, came to Calcutta and delivered the Tagore Law lecture,
yes,
titled From Marshall to Mukherjee.
yes. It's a published lecture. Yeah, and available.
Marshall is the fourth Chief Justice of the United States,
Yes,
John Marshall.
yes, my lord. That is where judicial review began. So let me say Marbury versus Madison. Lord, we are back after 1 century, 2 centuries. We are back to Marbury versus Madison. Why? I want to know why. Well, Lord, the attack of the other side, I will use a better word, a criticism of the other side, it's really questioning judicial review. That question is the most important question in these 7 questions. Please answer it. Are we being told that religion is hands off from this court? My answer is no. No, and I give you the reason why. India has a single set of courts. We do not have a separate set of ecclesiastical courts. Therefore, the Supreme Court has inherited ecclesiastical jurisdiction, but the Indian courts have had over the last 2 centuries. 1772 is when it began with Warren Hastings' proclamation, when he said that Hindus will be governed by Hindu law, Muslims will be governed by Muslim law. How is a dispute to be decided?
Jaising, if we have understood the submission, particularly of the Solicitor General and others, it's not a question of non-justiciability, but a question of deference. As in economic policies, so in matters of religion,
Yes.
courts will,
In other
as they say,
In other words, discretion.
fools rush where angels fear to tread.
In other words, discretion. my
So
lord.
we would
Discretion. In other words,
definitely not render ourselves foolish by
know,
treading
let
in
us not-
areas.
I'm not getting carried away by the words of the other side, but I've understood the question. I submit, my lord, with respect, I don't agree with this proposition. There is a direct attack on the right of judicial review. That is why you framed a question there. That question has to be answered. And he said, you have no power to decide, you don't have the competence, you don't have the power to decide what is the question of religion. How are you going to decide this case? That was the argument. In black and white, it's in writing. I say, yes, you have the jurisdiction. One answer was given by Justice Bagchi when he said, you can take expert evidence. Courts in India have been taking expert evidence for the last 200 years. Since 1772, when the Warren Hastings proclamation was filed, and those judges did not know how to decide a question of religious right. Every case they're relying on is decided before the Constitution of India came in. Who decided whether an idol has a juristic personality? Is that a question of religion or not? Who decided it? An ordinary civil court decided it in India. And today they're telling you can't decide it.
So if a person aggrieved comes, courts will definitely decide.
Yes, so,
Not
yes, so you
persons who are not aggrieved who come and ask to decide.
so the locus issue will come to that also.
Yes.
I'm on the jurisdiction issue. I'm on Marbury versus Madison. I'm on Article 226 and 32 of the Constitution of India. And let us also clear this confusion about whether I go for a civil suit or whether I go under 226 and 32. This question has also been raised. If there are disputed questions of fact, yes, Section 9 of the Civil Procedure Code will entertain any suit. Regardless of whether it raises a religious question or not, they will entertain the suit. And they have been entertaining it. But if I'm challenging the validity of a statute,
Most of the civil court, they are very plenary in nature.
Yes.
So anything it can be decided.
judgments of the court say this.
Section 9 of the CPC is always there. You should be respectful.
It is there in the CPC, which is continued. The CPC, the Civil Procedure Code, has not been reenacted. It continues in full force and effect. It's protected by 372 of the Constitution of India. Law in force. Before the Constitution came. Well, the whole of tort law in India is what? It's the common law. There's no codified law. How do courts decide? So if your religious practice is not codified, if it's a practice, if it's a usage, what stops from going into the question whether this will get the protection of the Constitution or not? Nothing. So some of these petitions have come before you by way of challenge to statutes. You have entertained petitions under 226 and 32 to decide constitutional validity. When you find that you have disputed questions of fact which you cannot decide, you may relegate the person to a suit. It's a different matter altogether. And one more issue, Section 92 of the CPC empowers the civil court to frame a scheme for religious and charitable endowments. And they have been doing it. So where are we on this question of judicial review which has been framed? The question is not judicial review by this court or by a civil court. A civil court can also go into it, can frame a scheme on how to run a religious and charitable endowment. Well, I'll substantiate it a little more now. I'm just telling you.
Nobody is saying, see, judicial review is a part of the basic structure. Nobody is trying to curtail that.
I understand.
Neither do we want to curtail our powers. The question is of entertainability and answering on merits certain aspects of the dispute.
Certainly, my lord, every day I've been sitting in this court, every day the learned Chief Justice has been saying, why aren't you going, for example, 32? Although Ambedkar said it is the heart and soul of the Constitution, why did he say it? Not because he wanted everybody to come here, but because judicial review is the heart of the Constitution. He didn't say it that all of you come running under 32. No. That is the reason why the learned Chief Justice, every time I've been in this court, he said, why are you diminishing the powers of the high courts? Go there. 226 is there. They're co-equal powers, and there are judgments of this court which say that 226 powers are beyond 32 powers. There are judgments of this court. So, my lord, what is the question we are deciding? First, I would like your lordships to decide what is it that you're going to decide in these proceedings, and go ahead and decide it. So, my lord, I understand discretion not to entertain a particular petition is a different matter from lack of jurisdiction. What was said is, you cannot decide questions of religion because you are not theologians. This is the argument I have to meet. If you're not a theologian, call a theologian to advise you. Because religion, what constitutes religion is a question of fact. It is not, or it may be a question of fact and law mixed. But how do you decide religion? It is written down. You have the Quran. Are you going to say that is not religion? You have Shastras to tell you what is religion.
No, the question is whether the court can sit in judgment over conscience.
Nobody wants that. We don't want conscience.
Whether the
Let
court
me make.
can sit in judgment over conscience.
Let me just make one submission on conscience, because questions were asked, how do you distinguish conscience from practice, or from religion? There is a dissenting judgment in the Saidna's case, where the dissenting judge, Justice Sinha, tells us what is conscience, and I'll point that out to you. He says, no one can be called to the bar to account for their conscience. That is conscience. Conscience is beyond calling me to the bar and telling me, why do you hold this view? And I'm not questioning. I'm not questioning that they hold a particular view. I'm questioning a practice. There is still a difference between holding a point of view and practicing. Big difference, not just a difference. I don't question their faith. You hold that view, I'm not stopping you. But in exercise of that view, when you violate my right, I have a right to come to you and tell you, don't allow them to violate my right by way of a practice. These two have to be dealt with separately. So, conscience, that is the reason why in India, I think universal jurisdiction, universal question of law. There is nothing called a thought crime. Crime does not address my conscience, does it? I can be sitting in my home and thinking, I wish XYZ was dead. Can you file a suit against, can you file a criminal case against me? You can't. Because what I think is not criminal. When I execute it, then it becomes a criminal act, as declared by law. And in criminal law, you have a distinction between intention and motive, etc., etc. We don't want to go into all of that. Jurists have argued that why you're making this distinction between motive and law, even motive and intention, when you're coming into the realm of criminal law. But that's a big debate, which I don't want to get into. You don't need to, but it tells you the difference between conscience and practice. There is a difference. The two rights are not the same. Now, let's come straight, my lord, to the question, what is the nature of the right? First proposition is, if you open Article 25, it's not a right, it's a freedom. Let us be very clear about it. See the heading. It's a freedom. So, my lord, it's a freedom in the sense that I'm free to do what I want to do, provided I'm not violating morality, health, public order, and other provisions of Part 3. I'm free. So therefore, when I enter a temple as a woman, you have to show me which of these I have violated because I have that freedom. And that is why I'm saying that the right of temple entry into a public temple, I'm clear, I'm not asking for a right in a private temple. Is a fundamental right guaranteed by Article 25(1) of the Constitution. Law or no law, that right is guaranteed to me by the Constitution itself. Now, we come to 25(2). In fact, in Devaru, if I'm not mistaken, this court has said 25(2) controls 25(1) and 26(b). Both. It is not as if 25(1) is not controlled. It is also controlled by 25(2). For want of a better word, my lord, I will call 25(2) the hero of these two rights. Because it controls both. It controls 25(1) and it controls 26(b). Now, my lord, I was a bit taken aback when I heard suggestions which agree with this proposition, namely that 25(2)b overrides 26. Submissions were made on the other side by some of the counsel. They didn't give it the reason why. Why? Why does it override 26(b)? People have been economical with their submissions, I would say. I won't say economical with the truth. Half sentences. Submissions have been made in half sentences. The logical conclusion of saying that is not drawn. If they agree that 25(2) controls 25(1), what prevents me from entering a temple as a woman? He said it. Mr. Gopal Subramaniam said it, my lord. I have been really enlightened by listening to so many people who know a lot more about religion than I do. But then reach the logical conclusion of your submission. That is not done. Why? Why are we playing hide and seek with this court? So, Manoj, I just want, my role here is to just say, according to me, what is the clarity on the questions that are to be decided by this court. That's all. Decision is a different issue altogether. So for that, what is the key to that? The key to that is understanding what exactly is the right to religion. What is it? What is the content of that right? Now that you can discover, as I said. One is, of course, your conscience between you and yourself. You need not go to a temple at all. If you don't want to go to a temple, it doesn't mean you're irreligious. It doesn't mean you're not a Hindu. But if you wish to go, then your right is protected under 25(1). That is a submission I'm making. Why? Because I'm addressing you on what is this right. So now let us understand what is this right. This has always been a civil right. And it's a right in rem. There's no magic about this right. It's a civil right. Somebody did mention it's a right in rem. I agree. It's a right in rem. But what is the meaning of a right in rem? A right in rem determines my status. Just as marriage determines my status. So if I say I'm a Hindu, it determines my status in law. If I say I'm a Muslim, it determines my status in law. So then the question becomes, this is the nature of my right. What prevents you from saying that this status right of mine cannot be violated by another person who's also claiming a right under 25(1)? Whatever be the nature of the right. We are two of us, both of us are claiming a status right under 25(1). They are claiming a status right. Why did Devaru come about? Because both were claiming a right to religion. Both. The denomination as well as the individual. So how to decide the question? That's why, my lord, the only way to decide the question. So I agree with all the three propositions. You need an essential practice test to resolve this tension. Without the test, what are they telling you to repress it? My bona fide belief. Who's going to sit in judgment over your bona fide belief? Please have it.
Madam, Devadu was not dealing with 25(1) versus 26. Devadu was dealing with 25(2)(b.
Yes.
A legislation and
Yes.
social reform
Yes.
versus 25(20).
Yes.
So
I stand corrected.
there is a very, very thin difference between the two.
Yes.
A social reform making an inroad into the freedoms,
Yes.
be it individual or be it collective,
Yes.
requires an interface which the courts would naturally decide
Yes.
with regard to proportionality and other tests as Devaru harmoniously construed.
No, with respect, I agree.
And when it comes to a situation where it's not a question of the state making an intervention, but an individual asserting practice rights versus the collective asserting matters of religious affairs.
Yes.
In
But-
our understanding,
Yes.
26 by the plain reading of the Constitution prevails over 25 individuals.
But that is what Devaru does not accept, and I'll explain why. Because both are, I'm now on the question of what is the nature of the right claimed by both. Both are claiming in essence a right to religion. Am I right there? Both. So whether you're claiming it under 25(2)(b or 25(1), it's the same thing. You're claiming a right to religion.
25(2)(b, madam, is claiming the state power to
Yes.
interfere in religion.
Yes, yes,
25(1) is claiming a individual right
yes,
which needs to acknowledge
Yes.
and tolerate the other individual rights.
yes, my lord.
of individuals. And there your point is very well taken, that one cannot be ignored in preference of the other. But what happens when that individual right is pitted against a group right?
I'll answer that. But first, let me give you the sequitur of what was just put to me. My lord put it to me that the state is claiming to make an inroad via a law. But the state is claiming it on whose behalf? On my behalf. The state is not claiming it on its own behalf. The state is executing the constitutional mandate. It's respecting, protecting, and it's obliged to protect my rights. The state is obliged, it's not protecting its own right. What are these entry laws? These entry laws are made for me. So they're acting in parents patria capacity to protect the rights of individuals. And therefore, my lord, that distinction doesn't hold when it comes to deciding how to harmonize. So the only way to do it is to harmonize. Now, the other side is telling you, throw away the essential practice test, throw away Devaru, throw away Shururmat, make everything and everyone a denomination. I, Indira Jaising, can say I'm a denomination. Why not?
See, freedom of conscience was not given to us on January 26, 1950.
Yes.
That is something which civilization has, with the evolution of the spiritual aspect of man, through the passage of, you see, years and years and years, it is something which has been evolving. Constitutionally, it has been circumscribed by certain aspects. Now the question is, what has been evolved by man over the civilization? How much of that has to be protected? And at the same time, protection of that, how far it will sort of inroad into the other aspects which are the riders for that freedom. That is the whole essence of this debate.
It is true.
Now, it's not that we got a freedom of conscience only on 26th of January 1950.
Yes.
It has been there for ages.
Yes.
So, but that freedom, how far constitutionally we have to curtail, that is the only aspect which has to be curtailed.
That's right. That's why I
Now,
said,
what has been developed over the ages,
well,
what has to be protected, cannot be taken away by the constitution.
yes.
That is the issue.
Therefore, that is why I said all the 6 questions can be collapsed into one. For a moment, forget the locus. This is the only question to be answered. All 6 questions lead you to this question. What is it that is protected? What is it that is not protected? That is the issue before these 6 questions. Now, will that question be decided on the basis of semantics as has been suggested by the other side, or is it going to be decided by the conscience of this court, by the conscience of the constitution, which some judges have called constitutional legitimacy and others have called constitutional morality? Forget words. How will you decide that question? You as a constitutional court also have a conscience. Your conscience is the Constitution of India. So this question will have to be decided with reference to the entire Constitution of India, not by looking only at words in 25 and 26. It's one indivisible constitution. How will you answer these questions? Just by looking at a dictionary and saying, this is how I answer. That is why I said in my written submissions, the first thing I've put down is how do you read a constitutional text? And there, even this court has referred to the proposition you read it as a living document. Forget constitutional morality. What is the meaning of living document? A living document, questions which the framers could not anticipate, you have to answer. And how will you answer questions which the framers did not anticipate? By looking at what? By looking at the constitution as an organic whole, you will answer that question. This question may not have been in the contemplation. All right, the question I'm raising, though I will tell you it was in the contemplation of the Legislative Assembly, whether women are untouchables within the meaning of 17. I will show you from the debates women are mentioned there. But whether you agree or disagree with that is not relevant to the outcome of this case. Article 17 is an additional argument. But the crux of it is this: who to exclude, who to include. This is the question. How far will your conscience take you? Will it allow you to do a practice which excludes another person who has a right under this very constitution? Does it allow you to exclude a practice? That is why I said, okay, conscience is fine, my lord. Nobody, I'm not questioning their belief. Maybe a Naistic brahmachari may not be. I don't say it's not. I don't say it's not genuine. I don't say it is not bona fide. But I do say these are not the tests evolved by this court. This court evolved the test of essential practice. Because it is not a subjective test. That is why this test was evolved. Genuine is a subjective test. Are you going to sit in judgment over the genuineness? I don't sit in judgment over it. Are you going to sit in judgment over their bona fides? I don't. These are the two alternative tests which have been suggested. But this court said, no, to harmonize the rights, the test is essential religious practice. That is the answer to the question, how far to protect, how far not to protect. A practice. And therefore, please don't throw out of the window the essential practices test, because if you throw it out, then the autonomy argument will prevail.
Can also not ignore the civilizational and religious history of this land
Yes,
while considering this issue. It is
yes.
in that background that these two articles have come about.
It is true, but it is also
Living document, organic, it's good. But let us not forget the
background.
the past. The
Yes.
past makes the present.
Yes,
We can't
Yes.
ignore the past and say there was a vacuum and on a clean slate we started the constitution.
it is a clean
debate.
slate. According to me, it's a clean slate,
Can't
but
be
we
in a
can have a
clean
debate
slate.
on that. We can have a debate on whether I take the view it is a clean slate, but I agree that the background to the drafting, may I just complete? I agree with you that the background to the drafting of 25 and 26 was the existing religions in India. It was. Whatever they may be. It was Hinduism, it was Islam, it was Christianity, it was Judaism, everything. That was the background. My Lord, everywhere in the world where I travel, I'm told, wherever I go, there's no other country in the world, no other constitution in the world which protects every religion. None. I challenge my friends on the other side to show me one constitution. Many constitutions have been cited in this court. Show me one constitution which protects all these religions, every religion. So that is background in which these two articles have been drafted. There's none, my lord. I can tell you, international jurists have given opinions on this, that India's constitution is unique. That is why it's called unique. But this is the reason why it's called unique. because it protects all faiths and because it also gets rid of all the limitations on the right by rejecting caste, by allowing temple entry, by removing all the disabilities attached to religion. That's the reason why it's considered a unique constitution. No other reason. You think of the consequences of what they're saying. What was the case about? That another Brahmin, except a god, Saraswat Brahmin, cannot enter that temple. That was the argument. You want to accept that argument? Their argument, what is the consequence? There'll be no temple I will be able to enter. It will be a complete balkanization of Hinduism. Torn to bits. Everyone will say, I'm a denomination. Whereas the history that is being told to me is the history of this country, is the unification of the different sectors, sects, call them what you like. Then there's a question which requires to be answered. In that case, why is 26 there? What exactly was the need for 26 in the Constitution of India? It did not have been there. Or you could have had, could you have, okay, let me reverse the question. Can you have only 26 without 25? Is it possible? It's not possible. Then comes the next question, what was the need for 26? That goes back again to the nature of religion in this country. That is the answer to that. Hinduism has been over centuries reforming itself. Religions reform internally. We are told, no, court should not reform religion. But the fact is that every religion reforms itself from within, if it has to survive, and if it has to have any meaning for human beings. And therefore, the history of Hinduism is the history of reform movements within Hinduism. That is why there is a need for denominational protection.
That is different from saying that the court should reform a religion.
It is very different. The court's only recognizing it. You are recognizing that process. Just as I was told that there's a background to these articles, similarly, there's a background to putting denominations there. The background is the background of reform. Tell me one religion which has not reformed. Same with Islam. At least in law school, I studied Muslim law from Faizi. I studied Hindu law from Mullah. So you take any book on Muslim law and Hindu law, you will see a history of reform in it. Because religion has the capacity to regenerate itself, to reinvent itself, if it is going to be relevant to human beings. It is going to have to reform itself. And it has done. And that is why the word social reform is there in 25. Where is it? 25 2b. These three go together. Social welfare, social reform, and throwing open Hindu Hindu institutions, religious institutions of a public character. The three go together. Reform of religion is social reform. What else is it? Are you reforming the economy? Are you reforming finance? Are you reforming a secular matter? No, you're reforming religion. And what's his name? I think Mr. Dhawan is there. Yes, he said, I'm an Arya Samaji. Yes, he is an Arya Samaji. He said it. He said it. But what he didn't tell you is that Arya Samaj does not believe in the sanctity of the Vedas. So there are changes. This is why a denomination must have a doctrinal change. There has to be something doctrinal in it to be a denomination. You can't say I'm a temple, so I'm a denomination.
Hey, madam, what is unique in India is diversity is our strength. And what section Article 26B does is to recognize the diversity. We are strong because we are diverse, and diversity is our strength. And to bring about a recognition of that diversity in denominations, Article 26B protects it. By giving such a protection, there is a unity also developed in the country. That is how we should look at it.
Yes, it is unity and integrity of the nation. Not only your doctrinal differences will be protected,
Therefore-
but your interreligious differences are also protected.
Therefore, respect diversity.
Yes, respect it, but show that you're diverse. Don't show me that I'm a temple and that therefore I'm diverse. Show me your diversity, no? I want to make one observation, and if I'm wrong, your lordships may correct me. In the 75-year history of this court, the only institutions that have got denominational status are mutts. No temple has been given denominational status. Surely there must be a reason for that. There are doctrinal differences. Therefore, the three-pronged test, an ideology that you follow, a theology that you follow, how does it change from the previous ideology? Then an organization. And then what's the third thing? Name. Name, as somebody pointed out, the word denomination itself includes norm. You show a doctrinal difference from the other religion, and all mutts which came to this court have been given denomination. Why? I am suggesting that two more. If you actually go through all the judgments, you will find two more tests which are not articulated in this way, in the way in which I'm articulating them. They have a living guru. Mutts. A temple doesn't need a living guru. But a mutt needs a living guru.
But temples are aligned to mutts.
Temples
They're all
are set up by mutts, but they are separate institutions. But every denomination claims to have a living guru.
Madam, what you are arguing is to read clause A with P. See, clause A of 26, 1A. Establish and manage religious institutions. P, freedom to manage the affairs in the matter of religion.
Yes.
So do you mean to say that the denomination must have a religious institution in order to enjoy 26 rights?
Not only that, I'm going to go a step further and say, what about C and D rights? It's property. They have property, my lord. Today, every denomination in
Property, madam, that we read, or at least prime of us I see, C and D independent of A and B. Because C and D is qualified with the words in as per law or in accordance with law.
no, not C. I'll get into that.
C reads into D. You cannot maintain property and administer property
Yes,
differently.
my lord.
They are
Yeah.
overlaps.
Yes.
So do we read these two, A and B together and C and D different?
Yes. It is true.
So-
But my question is, what is the second?
Definition, as you are saying, itself the constitution restricts the definition of denomination by positing the denomination or its section to an institution. Now that institution may be a mutt, maybe a temple.
Yes. Maybe is an open-ended question, but for the sake of argument, we may accept. We may accept it.
What is important
All right.
is
Okay.
the temporal existence
Yes.
of something which is an institution
Yes.
in fact.
Yes. In fact, in flesh and blood.
It may be a building, it may be a field, it may be anything, but then
Yes.
there must be a temporal existence
Yes.
in spatial terms.
That is the
In
three prongs.
space.
Yes.
What is occupying spatial space
Yes.
terms?
Yes. That is why Ramakrishna Mission was declared a denomination. It has a structure. It has an organization. It has a corporate personality. It has a name and it has a doctrinal difference. All must exist.
But you see, Auroville was not. And
Yes,
that is
now-
where we need to examine Mittal, SP Mittal, in relation to Acharya Jagadish Guru and Ramakrishna Mission judgment.
Yes.
Because there has been a little bit of a difference of views
Yes,
as to where we are identifying a denomination
yes,
or a section, we may read it by qualifying it with the institution. Maintain, so the denomination must come, it will establish and maintain an institution, and in that institution, the matters of religion are completely their exclusive domain.
in doctrinal matters, in doctrinal matters.
State cannot make an entry, even in exercise of social reform. This is the way the review petitioners have
Yes,
interpreted.
yes, even whichever way you interpret it. The question remains, when any practice of yours which is discriminatory, first of all, let us take the case of temples. Why? Because we are dealing with temple entry case. That's why I said I'm going to confine my submissions to the case of temple entry. It stands on a different footing from denominational rights. It's a standalone right. Even if there was no denomination, I would have the right to enter a temple.
It's correct. 25(2) does not speak about the religious denomination at all.
Yes.
It mainly speaks about, it is to be said, take care of two things, as you rightly said. One is the public, the social welfare and social order. That's one part. The second is with akin to the specifically referable to in the institution of public character. So long as these parameters are satisfied, we need not go into section 26 at all.
Yes.
Like you said, for a religious denomination may have number of institutions. They will come under the purview of 25(2)(b), provided the institution which they are maintaining or managing or administering, they have a public character.
Number one,
As
public.
simple as that. So
Yes.
yes,
And that they are religious,
Understand.
qualified by religious. That's where the doctrinal aspect comes in.
religion is, see, when the state is expected to invoke 25(2)(b), it actually deals with the religious practice
Yes.
on the face of it. There's no dispute on this because that is not a case of 25(2)(a).
Yes, yes.
But both the state and then if on a judicial review by the court, we are concerned with only with the social welfare or the social order only. We are not. It will have an impact on the religious practice. It may have as you rightly said, it may lead to the consequence of a religious reform or a religious belief. But we are concerned when you look at it, you will look at the prism of social welfare,
Yes.
of the social order.
Yes.
To that extent, we agree. We follow you.
I could not have put it better. That is my submission. What do we mean by social reform? That is why I said social reform is reform of religion also. Otherwise, why you need it in that article? What for? Why is it in a chapter on religion?
But one thing you must bear in mind, matters of religion in Article 26(b) is not restricted to essential religious practice.
Yes.
You can't give a restricted meaning to matters of religion.
Right. Therefore,
But at the same time, Article 25(2)(b) can operate. Both have to be harmonized at the end of the
yes,
day.
yes.
That is Devaru.
But
By restricting the expression matters of religion
to
to essential religious practice only
yes,
will
yes.
be causing damage to that expression.
So therefore, we need to understand why it was included, why it was imposed by this court. May I put it
Just
that?
as only invention of this court.
That is what, yes, but
That is
the
why they're
question,
saying don't
no,
go by
yes,
that.
yes, I've understood them very clearly, and I must make it clear that even my friends on my side are also going to argue don't have it. I know that, but I insist on it, and I'm giving my reasons. Because,
What are you doing with your mobile? Keep it in the pocket.
I beg my,
Why are you recording? Keep it inside the pocket.
okay. So I want to explain the reason why. On a plain reading, this answer is correct. On a plain reading, it is all of religion, essential and non-essential. But how will you, as a court, resolve the question when both are claiming a religious right? That was the discussion I was having. Two people are claiming a religious right, and both of them are saying this is the sum total of religion of my rights. Essential or non-essential? How are you going to resolve that?
See, it is not a question of claiming here.
Yeah.
It is an enabling power for the state
Yes, it is.
to reform.
Yes, it is.
Now, when a piece of legislation is made by the parliament or the state legislature with regard to reform under Article 25(2)(b), the question is whether it is making an inroad into a matter of religion
Yes, and
or whether it is a matter where it is a reform per se.
yes, it is.
Now, there has to be some kind of a balance drawn. In that context, the submission is, don't say only essential religious practice.
Then say what?
It is
How will you,
a matter-
what is the alternative test given to you?
May be a matter of religion, but in the name of social reform, a religion cannot be hollowed out. That was the submission made.
I'm trying to say two things. I'm saying in the name of religion, religion itself, all right, this is the right time for me to give this answer.
As your colleagues are going to argue, as my sister put it, it can be the essential part of the religion can be looked at from both sides.
Yes,
It will also help you in a way,
yes,
in the sense,
yes, because,
if you remove essentiality
yes,
and keep only the social reform or social welfare, then it will give you more flexibility to the state to do it.
well, not yes, it is true. The outcome may be the same. Because you will harmonize with social reform. You can't get away from harmonizing.
25 does not say anything about essentiality.
Yes, the
But
question.
only thing is we are trying to put it to you. When we deals with it, court will have to be a little bit more circumspect when it deals with an essential, because it is not the practice that is concerned. It's a
Yes.
belief. See, when it encroaches upon the belief, the practice which encroaches upon the or you can't segregate it from the belief, then both the state and the court will have to be more careful and circumspect.
Yes, my lord.
Even assuming when they access the power in 25(2)(b).
Yes, yes. My lord, as your lord put it to me, you will have the benefit of both arguments.
Yes.
You will hear the argument from one of my colleagues that you don't need the essential practice test at all. From our side, that means those who are supporting temple entry will also be arguing this. Why? Because the outcome may be the same. Whichever way you decide, the outcome will give me my right to enter. Okay, but the question is, you can't do away with the harmonization principle. That is it. Now the question is, what will you replace it with? With what will you replace the harmonization principle? You need a test to harmonize. Get rid of essential practice. It was put to me, social reform. If I can show you it's a bona fide social reform, you will accept it. You will accept it. All right, don't go by the essential religious test, go by the social reform test. It's fine. The outcome will be the same. Certain rights of mine will be protected. I am here before you to say, protect my right. This denomination can't keep me out, or this religion can't keep me out. Today I'm dealing with the temple. Now, my lord, second criticism of the essential practice test is this, that a civil court or a constitutional court can't decide. My answer to that is, it is not a civil court or a court. All every religion is there. This how question is that? Not because the court thinks it's not essential. That religion thinks it's not essential. Let me be clear. I am not saying, all right, you decide what is essential. I'm saying your own religion, even in Hinduism, there are dictates which are mandatory and there are those which are advisory. And every normative system of law makes this distinction. Justice Bakshi said that. He said, is there no distinction between void and voidability? Is there no distinction between mandatory and advisory? There is. In every system of law. It exists in Islam, it exists in Hinduism, it exists in the Constitution, it exists everywhere. How many times your lordships have decided that this particular law is not mandatory. It is only advisory. So it is there. I don't want confusion on these issues. Whichever test you use, you use. But it is false to suggest that this court is deciding what is essential. No, that religion itself is deciding what is essential to me and what is not. And that test is being used for harmonization. Now, if you still want to get rid of the test, it's fine.
Madam, to what extent do you want this essentiality to be gone into by the court? We're not very clear about that. You said you keep it, but then religion will decide. What ultimately is your crux of the argument? What do you want? You want the court to go into the religiosity or the essential religiosity of a thing? What is your clear-cut stand on?
I am only saying this much. Theology is a matter of fact because it is written. For example, it's written in the Quran, in the Hadith, in the Vedas. Nobody's been able to date the Vedas so far. We don't know what is the date of the Vedas. In the Puranas, in the Agamas. It's all there, right? So what is a matter of religion is a question of fact, is my argument. It's a civil right at the end of the day, raised to the level of a constitutional right by this constitution. It, as my lady put it to me, it always existed. It's inherent in being human. We all have that right. We didn't need a constitution to give it to us.
But it has been raised to a constitutional right, but then qualified also.
Yes, yes.
Alan, what
So
is
I
the
said-
according to you? You're not
I said,
clear about that.
Milord, I agree. That question can only be answered case to case. I agreed that the limitations which are there in 25, I'm bound by those limitations. I can't claim a right outside those limitations. I can't.
I'll give you a basic example. Suppose there's a religion. There are minorities inside religion also.
Yes, there are.
Their denomination and any other section, the constitution uses those words. Now, if the court gets into that, what is the parameter? Should I decide with the majority view of religion by oneself?
No.
Why do I get? How do I? Am I competent? Is the court competent? That was another question. Then we have to answer that.
Milord,
Who
that is,
decides all that?
that's right.
We become
Milord, that,
theologians?
your lordship used a very interesting word. Your lordship said minority. That word has not been used till today, till now in these proceedings. Minority. Minority within a religion. What happens to a minority within that? In a different form, the question has been raised by Justice Bakshi. Can two people dispute between themselves what is religion or not? That question has also been raised. So the minority, let us understand what is a minority. It is not a minority. It's a minority that has a difference of theology. The main religion, that's the denomination. Distinguish a denomination from a denomination. What is it?
No, it is not so compartmentalized, madam. The difference may not be denominational. It can be only ritualistic. It doesn't make a denomination or theologically different. It doesn't. I have to perform something. I do it in a particular way. That
Yes.
doesn't mean that the theology is different.
That is ritualistic. Ritualistic is part of theology. Rituals are part of theology.
But that will not form the core of theology because ultimately
No, it
what
won't.
a group
That's
is.
where the essential difference and non-essential comes in.
Who
It
decides
doesn't
all
form
that?
the core of theology, I agree.
Who decide that? Every time if the court intervenes, there is a limit. You are very correct, case to case basis. But then sometimes some minorities have to be given, otherwise the whole protection of the constitution appears to be illusionary.
No, the answer to that is the religion itself decides. I've said it. I am not inviting you to become theologians, but I am inviting you to say, please have knowledge of what is the theology of this particular institution. Have that knowledge with you and then take your decision. What prevents you from getting that knowledge? Everything is available to you. What is not available? The Vedas are available, the Puranas are available, the Agamas are available.
When there is a difference, which prevails? Do we intervene in that?
No, that also the religion itself decides. It decides.
That is the contradiction in argument.
That is where,
Religion
where,
decides and then you say, no, you decide.
that is where, if such a dispute ever arose in British India, let me go back to British India. If such a dispute ever arose In British India, the judges used to call the theologians to the court and ask the theologians to give evidence about it. Because religion is fact. How do you discover how are you? What is
Finally, on a particular, probably you have to assist on that.
Another thing, Article 25(2)(b) does not create a right. No right is created in
It's an endowment of power.
It is only a conferment or enabling power to the state.
Yes, it's a conferment of power.
Now, when the state makes a legislation, if there is a challenge to that legislation, then the question would arise.
Yes, it
But
will.
under which right, which is the right which is being claimed under which law?
Yes.
The right of entry is being claimed.
Yes, yes, the question is that how to decide it.
Where is the right of entry?
Is one
Let us say, for example, let us say that they say anybody south of India's, because everybody is referred to as south of India's. Anybody south of India's is not permitted entry into any temple in Kashi. Then can that not be curbed? Suppose the temples of Kashi say anybody south of India we are not permitting.
Hindu, a Hindu.
Hindu temple.
Yes, an Hindu trying to enter.
State will come up, either the parliament or the UP.
Yes, yes,
State,
yes,
state can make a law
yes.
that temple entry, it is open. This ban, such a denominational, what you call, suppose they had a religious congregation
yes.
and read this resolution. To get over that, the state will come up. But Article 25(2)(b) doesn't create a right in anybody with regard to temple entry.
It does not. It is
Does
an
not.
endowment of power. It is an endowment of power. I didn't say it's a right under 25(2)(b). I didn't say it. 25(2)(b) immunizes such a law if it is made.
Well, madam, then we again come back to the basic question. Basic question is lifting the wheel of your intent also. Suppose, wouldn't it be believed that you are a true believer, but you go to a place, you violate that. Is it the role of a true believer that I will go there, but I will violate the general predominant sentiments? I will do it in my way. Is it a belief? And then we'll have to maybe lift the veil of your intention also. Whether it is maintainable.
I will answer that.
What is behind that?
Madam Indra, I think our questions are also now enough to understand so that
Yes.
proceed further.
Yes.
Just a bare idea. Probably 25(1) is your real hallmark.
Yes.
Where you are conferring, you are
Yes.
seeking right.
Yes. Not
Just-
right, I'm claiming a freedom.
Exactly. So, in terms of to understand whether 25(1) confers a fundamental right to enter let us give by simple example, to enter into a temple,
Yes.
or does it recognize a right to enter the temple, which was very much there as on 25th January 1950 or
Yes.
prior thereto?
That is why existing laws are saved.
If you are able to probably propound your theory that 25(1) confers an independent right to enter,
Yes.
then what you are saying probably.
Yes, that is precisely what I'm saying.
But if 25(1) is only a recognition of a pre-existing right,
Yes.
then situation may be slightly different.
Yes.
So probably I think on that premise you can proceed.
Yes,
further.
Lord, I'll try to
But
answer
for that
question,
purpose,
but that is my
also
submission.
please keep in mind the language of 14, 15, 16,
Yes.
17
Yes.
and 25(1).
Yes, 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 my lord. And is the question, that is my submission, that I get my freedom from 25(1). What are the limitations? Ones what are written there. In addition to that, a Hindu has a right to enter a Hindu temple, right? Hindu as defined by law. Okay, as defined by law. For the moment, I'm not getting into the question whether a non-Hindu can get in. Let me confine it to Hindus. And this, so now I want to address the question put to me about, can I interfere with the ceremonials inside the temple? That is where this court has drawn a line. So the line is not drawn at entry. The line is drawn at the stage of ritualistic performances. That is where they say you cannot do what the agamas don't allow you to do. The rituals, that is the answer that I will give, at least in relation to Hinduism. I can't go there and say, no, this is not the way to knees namaz, that is the way to offer namaz. I can't do that. Why? Because it's part of the ritualistic part of that religion. And this court has protected ritualistic practices. In every case, protected. Then I can't say, oh, the pujari should not offer a coconut, but offer some flowers or whatever. These are ceremonial and ritualistic practices, which this court has put beyond the review of any law, beyond the mandate of any law. That's why the closest that this question arose in this court was in the two cases of appointing priests. That's the closest answer. You give me that, Anantya. Yeah, I'll read that. There are 3 judgments of this court which address that issue. And Adishaiva, Sheshamal, and there's a third one, Adintyan. These three together address the issue of protecting rituals and how to perform a puja. That is where they said that abolition of hereditary priesthood is constitutional, provided they have knowledge of the agamas. You can't touch that. No law of social reform can tell you how to change your agamas. So there is a protection. There is this residual protection. You call it residual, call it expansive, call it what you like. The point is, it has never been challenged. Okay? And I today don't intend to challenge it. It's an academic question for me. Tomorrow a woman can say, I want to be a priest. Possible. Question has never arisen. Even for the first time, the question has arisen in Sabarimala whether keeping a woman out is constitutionally valid. Until 2018, the question didn't arise. So what questions are going to arise for you in the future, I'm not going to say. But I am going to tell you what this court has done. It has protected ritualistic ceremonies and said these are beyond social reform because they are the core of religion. So therefore, it is not my case that you can change those practices. I'm not arguing that today. Maybe people, I'll tell you a very interesting, it's a small story, 2 minutes just to lighten the atmosphere. One of the women lawyers came to meet me. She saw me very agitated all the time, wondering what I'm going to argue in court. I was confused after listening to 55 counsel on the other side. I lost my mind. So she came to meet me. This young lawyer, she's here in this court, practicing in this court. She said to me, Madam, why are you so worried? Never mind. Let them decide what they want to decide. Let them say that a woman can't enter. We are here, no, we are the younger generation, no. I'm giving you a promise. If this court decides that women can't enter, we are there to reopen the judgment. She said that to me. That's the day I decided, let me not get confused by what my opponents are saying. Let me not think what's going to happen after me.
Let us not open rituals and
Yes.
practices which have been there over centuries.
So
Let this court not open such things.
with respect, I agree, because that is the law declared by this court so far. It has been protected. This court has protected those rituals. But the religion itself can reopen them. The church in England has allowed women to become priests.
So did that lady colleague of yours say that we'll flout the orders of this court?
No, no, no. They said that there is always the power of review and the power of curative and everything.
In the manner known to law.
Yes, in a manner known to in a manner known to law. So they said, all right, 9 judges, we'll ask for 11, we'll ask for whatever. Well, I'll tell you something. It's again an aside, but a very important one. Answers the question of locus. It answers the question of locus. My lady has been saying, how can you reopen judgments? The history of this court, unfortunately, and I will say I agree with my lady Justice Nagaratna, that a binding judgment of this court cannot be collaterally attacked by an Article 32 petition. I agree. But it has been done. It has been done in cases which I have appeared in. And these are the cases they're relying on. By the way, what was the sheet anchor of their argument? TMA-5. What was TMA-5? It was an Article 32 petition to open Unni Krishnan, reopen Unni Krishnan. I appeared in the Unni Krishnan matter, which said no capitation. They wanted to do away with no capitation, so they filed a petition under 32 and this court entertained it. So don't blame us for lack of judicial discipline.
We have to maintain discipline, that is important.
It's been happening.
Which is important.
It has happened in my cases. I was appearing in TMA-5. I resisted it. I said, I argued Unni Krishnan. You show me why Unni Krishnan is per incurium. But an Article 32 petition, and that is the only case they're relying on. Now you know the reason why they're relying on it.
No, I'll draw an analogy. You said that every religion is open to reform. So this is by part of a reform. We change our views. So give us something.
All right, my lord.
Law is fluid. Law is also
Let me
living. Constitution is a living document.
My lord,
You
lawyers
also
will be
evolve.
happy. Lawyers will be very happy if you entertain 32 petitions. I
The
will
thing is
come and
that
fight.
this side, both sides should be clear in the mind, open in the mind. Intention should be very clear.
I will also come and file 32 petitions if you're willing to reopen, settle judgments. Why not?
Not so casually. Not so casually.
My lord, I'm telling you, the only losers in this court are the ones who obey the law. We are the only losers because we don't file petitions in closed cases. I'm telling
You
you.
don't have to be so narrow. Law is only for the law abiders. As simple as.
Yes, but
So that doesn't matter. It's a fact. But then there has to be we have to live by the rule of law.
yes, law is for the law abiding, but where are the law abiding people in this country? I'm not talking about judges. I'm talking about this side of the bar. I'm talking about my worthy opponents. Why are you so angry with me? Gopal. Okay. Thank you. Thank you. Because Mr. Subramaniam made the submission. He said 26(2) overrides. What does it mean? Tell us what it means. What can you do and what can you not do? You can't make half submissions in this court and get away with it, my lord. The logical sequitur will have to be drawn, or you withdraw your submission. He is at liberty to withdraw his submission. So my lord, that is why I said I need that. I deserve that prize now. That prize I take for Mr. Singhvi. Why is he not here? Mr.
But
Singhvi.
now you are on shaky ground. The way you are reacting, now you are on shaky ground for that award. What you did not do then, you are now doing it. You can confine your arguments.
All right, my lord. Yes, that grave and sudden provocation has gone. So, my lord, the 3 judgments of this court which answer the question raised to me are Sheshamal, Adishaiva,
And third,
and this one, and Adyantam. All 3 dealt with this question, the extent to which you can interfere with what has been called the core of religion. And the 2 held that abolishing a hereditary principle does not amount to interfering with religion, so long as the person who comes in knows the agamas. And at least in the state of Tamil Nadu, well, Lord, I must tell you a small thing. I'm being assisted in this case, first of all, by an all-male team. And secondly, I don't know what to do because one of my AORs is called Parameshwaram. No, your amicus is Parameshwar. And my AOR is Padmanabham. And there was one more person who had a similar name. Anyway, these two are surrounding me. And my friend who was assisting me, Mr. Manuraj, has authored a book on temple entry being published by Penguins. And my lord, hopefully it will be available before the decision comes. So I would just, I would request that these books, including Mukherjee's book, should be made available to this bench. Because rather than taking it from me, what is religion and what is not religion, or from Mr. Gopal Subramaniam, I know he's an expert on the subject. You can ask him. When I want clarity on what is religion, I go to him.
These types that contains the lectures of Mukherjee.
These books must be available to you before taking a decision. So let me say why. Let me give you the argument why. Because you are dealing with pre-constitutional laws and post-constitutional laws in this case. That's the first reason why all these books must be available. You are also dealing with judgments of the Privy Council. Let us not forget it was the Privy Council which held that an idol has a juristic personality. Where did it come from? From the Privy Council. So you're dealing with Privy Council law also. And you're dealing with the Constitution. Finally, these are the three issues you're dealing with. So the question is, what is the domain of the law that you're dealing with? The domain of the law that you're dealing with is the law relating to charitable and religious endowments. There's a branch of law known as the law dealing with charitable and religious endowments. And these laws generally cover both charity and religion. That answers the question of corporate body and incorporation. Because these institutions are incorporated either as trusts, whether the trust has dual ownership between beneficiaries and the trustees, or whether, as Gopal Subramaniam said, they don't have that dual ownership, it's still the law of trust.
It can also be a debatter
Yes.
to the treaty,
What is debitor property? Property which is dedicated to an idol.
to the deity.
Yes, to the deity.
Even without a trust,
Yes.
the debator will have
Yes.
dependent jurisdiction.
Yes, it has.
That is what Mr. Subramaniam argued.
Yes, I agree. I agree with that. It does have juristic personality, thanks to the judgment of the Privy Council. What is the sequitur of that? The sequitur, now if that juristic entity has to act in the material world, what have the courts been doing? They've been framing a scheme under 92 of the Civil Procedure Code. Why is 92 there? 92 is there to give a corporate existence to a religious institution, which it may not have. What was challenged in Ratilal, the Bombay Trust Act? A religious institution was incorporated under a trust. So that corporate entity has to exist somewhere. So what is wrong with the three-pronged test which the court has evolved? It's the corporate entity which holds the land, unless, as I was told, that the dedication is to the idol. So the ownership then becomes, it's a separate species of property, which is dedicated to the idol, and which then can't go back for any other rule. Then all those questions will arise, whether Cyprus doctrine arises or
It's not,
rule against perpetuity doesn't apply.
it's not really been seriously contested on this point.
Yes,
What is being contested when an expansive definition of denomination is given is that we should not restrict it only to a doctrinaire approach, but matters of religion must be seen in the form of professing and practicing
yes,
religion
yes,
as the forms of worship.
yes,
And if a particular denomination or its section
yes,
has a unique form of worship or a practice,
yes.
that would also stand protected in respect of that temple or that religion institution which is established or managed.
If it survives constitutional scrutiny, yes.
Level at which the review petitioners would urge us to read the word denomination or its section, not at the macro level of a big philosophical schism.
Yes,
There is a big philosophical schism and a breach in religion.
yes,
Like if you see why Jainism, Buddhism has been always clubbed with Hinduism,
Yes.
is because they are all reformist expressions of the primary Vedantic philosophies in Upanishad. So it is not where they would like us to hold the definition of denomination, as has been done in Sheshmal and series of decisions thereafter. They would like us that it is also at the management micro level of how the prayers are offered, in what manner the prayers are offered,
yes.
and in particular cases, whether certain groups of persons will be permitted to offer prayers or not. So there, the denomination, I would rather say the devolution or the more my granular level of denominational interpretation has been.
Yes, my lord. Let me assume for a moment that is correct. Let us, for the sake of argument, agree with that. But the point is, no claim is being made either in a denomination or a non-denominational institution. Both. In both, you can't interfere with the rituals. In both of them. It is not as if
That's debatable.
it's a fact, my lord. I can't enter a temple and say this is how you have to perform the rituals
Unless you
as my ladyship.
rights, until and unless you claim 26 rights, the subordination of 25 rights with other provisions of the Constitution.
So they can claim it under both. They can claim multiple rights.
For individual claimants,
Yes.
freedom to profess their religion and conscience is always eclipsed by the denominational
It's the other way
practices
around. My lord,
in
that is the
religious
dispute.
institution.
That is what you have to decide. It's the other way around. The denominational right is eclipsed by the individual right. That is my case.
What you will.
Yes, yes. It exists for whom? For me. But I want to make this clear. I'm not claiming a right to interfere with rituals, whether in denominational temples or non-denominational temples. Let us be clear about that. Supposing it's not a denomination and I enter a temple, can I go there and say you perform this way or that way, or a mosque? I can't do it. It is not a claim. And the way the law has evolved over 2 centuries is on the question of temple entry. That's the evolution of the law. So the question is whether you can keep anybody out for any reason whatsoever.
To a fundamental question. Are you in agreement with the proposition that this right can be enforced only by a devotee who wants to visit a temple? Is that a fundamental claim or not? Or I just as a casual visitor, I just want
Yeah.
and I do. First, let us be clear, then will be the specific question. Let us be very clear on this basic.
Yes, my lord.
Are you in agreement with the fact that only a devotee, it's not a casual place, just go visit?
No, my
Is
lord.
it, we are at item on that?
No, I'm not in agreement.
Then
I'm not
you
in
want
agreement.
that everything
As
to
I
be left
said-
open to everybody?
As I said, the limitation that most of these laws impose on me is I must be a Hindu.
I'm not on law, I'm on the basic belief.
Basic.
I do not give yourself a name.
My lord, I can tell you straight off, I believe everyone is welcome in the house of God. If you want my basic belief.
No, no,
Who can be kept out of the house of
we
God?
are not talking about your belief.
Yes.
We are talking about
The law.
person
The law.
moving to a court for enforcing a right. Is it available to a believer? He may not say, I will not call myself XYZ, but I a believer in the place where I'm going. Is it not the basic to begin with? Then
Oh, I see. Whether your lordship is asking me a question, whether when I enter, why am I entering?
exactly, because you are entering a specific place, because this is on facts
Yes,
only.
yes, I will.
So you are a believer. You are a believer?
One
For
second.
that, because you believe that there you will get some solace, you believe
Yes.
that whatever force
Yes.
or the deity there is,
Yes.
that is, we are together on that.
Yes.
Now the question would be, I go there as a believer. How do I get the knowledge that what I believe, that deity or the person has the power? I believe because I have been told. If I've been told certain things in a package, can I say that, yes, I will say that, yes, I accept that it is a deity, it is a pious person, but I'll not believe that what he also wanted.
Yes.
He did not want this to be there. Can it be that I bifurcate from that because your belief, basic belief itself stands for something which you have heard, you have not seen that person, you only perceive. Can you say that that person, that restriction from immemorial time, you will believe half of that? Yes, I want to go there, I believe, but what he or she or whatever is the force, it said, I will not believe this portion. Can you bifurcate at that stage?
Okay. Well, Lord, first of all, I have not accepted the proposition that I can go there only if I'm a believer. Let me make it.
I made it very clear.
I'm
Now we are
also
back to
making
square
it
one.
very
Then you are done.
I will give the reason. You asked for a reason. I will give you the reason. Somebody here, Vincent Natraj, in answer to a question said, what do you mean by conscience? His answer was introspection. Am I right? We heard the word introspection. I need to go with reverence. I need to go with shraddha. I can't go there for the purpose of making mischief,
No, Shraddha itself
creating a
includes.
dispute. But I
Shraddha
don't have
itself-
to necessarily agree with all that.
What is
Lord,
into
how many
Shraddha?
of us go to temples where we don't necessarily, that is what Hinduism is. How many of us go to temples without really believing in that particular deity? We do.
Right.
I have done all the char
It
dhams.
is accepted, but where it is not a restriction. I think 0.001% may be the restriction somewhere. That too at certain point of time, there's no, as per my knowledge, there's no complete bar of entry in Hindu temple. You may correct me.
Yes.
But that is my.
There's no bar in Hinduism.
Sometimes.
If entry
because
of,
some
okay,
restrictions.
show me. Let anybody, I challenge my friends, show me in Hinduism, in the theology of human Hinduism, show me a bar on women entering temples. Show. It's not there.
Then we come to denomination and other sections. Then the languages used in the define separate. It's not question of one blanket. We can't be, you are right. Every fact of the case has to be gone into.
Yes.
So how
Yes.
can there be a total yes entry or no entry? How can there be straight jacket formulas or compartments?
It can be a formula for a Hindu to enter a public place of worship. A public place of worship. I can be kept out of a private place of worship. But
Public
I am
place of-
saying,
Public place of worship.
yes,
It's not a public place per se, public place of worship.
yes, of worship.
Public character.
It has to have that worship component is more heavy in that public place.
Yes.
Worship means whom? It's the worshipper who will go. I can't say that I'll go, I want to visit, I want just to see the face.
Supposing
do that.
supposing I were to tell you, first of all,
To add to my learned brother's points, will a follower of a particular idol or deity or question that custom or usage is the question.
that is the question that has been asked by Mr. Justice Bakshi for a long time. Can there be an intra-religious dispute? That is the question. At the level of debate, yes. At the level of debate, yes. As a question of fact, it will be supposing two of us are disputing. Take this very dispute. They are saying that there is a custom and usage. Let me give an example. They are saying there's a custom and usage, women can't enter. All right, between age 10 and age 15. They are saying it. I am saying there's no such custom and usage. What can I do? I can file a section 9 suit. Why not? I can. And then it will be for the court to decide on well-known principles of law. That is how I would answer the question, can there be an intra-faith dispute? That is exactly how religion has reformed, by intra-faith disputes.
That is different from a court creating a right for you.
But I'm saying I don't need a court to create the right for me. I'm saying the Constitution creates the right for me. Either I'm right or wrong. I'm not asking the court to create a right. You tell me whether the Constitution of India gives anybody the right to exclude a woman from a temple. I will sit down. I don't need to argue anymore. I'll take your judgment and walk out. Somebody said, oh, the whole world will be watching this decision. Yes, they will be watching, but what will they watch? They will watch whether the Supreme Court of India permits women to enter temples or not. That is what they'll be watching. Go ahead and
We
decide.
don't subscribe. We are not for the world to watch what. That is probably not for us to do.
No, but he said,
Everybody has a right to his own views.
what is there to watch? What is there to watch is what is the jurisprudence of the Supreme Court of India. That is what everybody, the whole world will watch. So whether the jurisprudence of the Supreme Court of India will enable women to be kept out between the age of 10, 55. And I make it clear again and again and again and again, I'm not going there to interfere with your rituals. Denominational or non-denominational. Both. Why confine rituals only to denominations? Every temple has rituals. What is religious law? Religious law, that's what it consists. According to me, it contains three things. One is ritual. The other is doctrinal. Obviously, there is a doctrinal element to it. The third is ceremonial. And the fourth is a form in which it is incorporated. Is it incorporated under a trust? Is it incorporated under an act? What is the form which it takes? This is known as the law of religious and charitable endowments. Now let me answer the question, why are the two lumped together? Why do you lump charity? Why was Mr. Arvind Datar here? Because he wants to expand the definition of charity. He said, I'm a tax lawyer. Well, not read the institutions which are given tax benefits for being charitable. They include the biggest private universities of India in the name of education, which is charity. And the IT Act, and I have put IT, I've given you a list of acts which govern charities. One of them is Indian Income Tax Act.
So if I understood you correctly, I think I'm more clear in my mind. If I've understood you correctly, I'm being very specific, that your target is the custom. According
Yes.
to you, custom should not be given the protection of a practice.
Yes, yes, it is.
And you
And
bring
that
all
will
this
take
into
you-
customs, entry and all being to customs.
Yes, it is. I'm obliged, my lord. That is the question that I will be at.
Such a right can be traced to 25(1).
Yes, my lord. That's all. After discussing all of this, it's a prelude to this question. It's a prelude to this question, and my Lady Justice Nagaratna has been asking this question from the first day. What do you understand by Article 13(3)(a) of the Constitution of India? This is what I understand by it. Any custom, any usage which violates any of my fundamental rights will not get recognition by this court. It's exactly the question, my lord, the custom, the usage.
Then you have to elaborate on practices. Practices
I will.
Be very open.
I don't have to elaborate. Hindu law has elaborated on it. I don't, that's why I said this all dried and dusted these issues. I will elaborate on practice. There are two twin restrictions in 13. One is having the force of law. That is the elaboration. All I have to prove to you is it has the force of law. Second, I have to prove is it a custom and usage. If I succeed in proving these two things, it's void, not voidable. That is the distinction. That every system of law will distinguish between what is void and voidable. The Hindu Marriage Act makes that distinction. You can validate a marriage which is otherwise void by option. That is why the women under 18 are given 2 years to make up their mind whether they want to stay in the marriage or get out when they were married below the age of 18. Within 2 years, you can repudiate the marriage. There is the right of repudiating the marriage. On what doctrine? On the doctrine of void and voidability. Because if it's void, it's void. But if it's not void, that is a distinction between whether we like it or not. It's a matter of semantics, whether you call it essential or non-essential. You call it mandatory advisory. You call it void voidable. The jurisprudence exists. It's part of the jurisprudence of all laws. There's not a single system of law which doesn't have this distinction, not one. So I'm not asking you to invent these concepts. I can't help it, my lord, if 55 lawyers have confused me. I can't help it, but I want to retain my clarity of thought. And are we agreed on one thing? I was asked whether I agree, disagree. Are we agreed on one thing? That when you read the Constitution of India as an organic system, 13 will come in, 14 will come in, 15 will come in, 19 will come in, 21 will come in, 17 will come in, 25 and 26 will also come in. That's the meaning of reading it as a organic whole. But what I want to say is that one of the main reasons, that is what jurists and authors have said, that in India there was not one revolution. Some have said 5 revolutions were taking place at the same time. One was the revolution for independence from colonial rule. The other was a revolution for social reform. The third was a revolution for undoing untouchability. That is why you have to give due respect to each article. Only then you will understand the Constitution. Otherwise, how do we understand it? Why is it there? Why is 17 there as a self-executing article? For what purpose? It need not have been there. We already had caste disability removal laws in India. They exist. They are pre-constitutional laws. But you needed that because Indian society was structured on caste and on patriarchy. These are the 2 structural principles of the Indian society. And both were undone by the Constitution, both, not one.
You said that you want the essentiality test to be upheld. Essentiality. Now, is it not a fact that for centuries, certain things which may have begun as customs or usage have crystallized and now form a part of the basic character of that? Suddenly, out of the blue, after centuries and all, it comes up. Now it has crystallized and moved on from mere custom to an essential part.
Yeah.
You can't forget history. There's always
I'm not forgetting.
it is continuity, especially
I'm not
for
forgetting.
all.
There is a continuity. And that is why
You
there is.
have to explain that why it now moves, maybe for argument's sake, it may have started as a custom, but then after so much of passage of time, it has now been transported itself as a basic element of religion. Why
Yes.
can't we? Suddenly, after so many years,
Okay.
somebody comes up with a grievance.
Yes, yes.
When all this is established and documented, it's not that no, we used to go.
Yes. I'll give the answer to
You'll
that.
have to assist on
I
that.
will answer that question. I will say it by saying there's a qualifier. In 13(3)(a), there's a qualifier. What is that qualifier? That custom must have the force of law. If it is a voluntary custom, then nobody is asking for invalidation of that. That is why.
Again, you are
I will
on the
explain.
shaky ground. What is voluntary? What it is?
I will-
What actually
I will
happens?
tell you, I'll give you a direct answer. If a woman voluntarily doesn't want to go to Sabarimala, don't go. Where is the compulsion?
The compulsion
It's
was that
voluntary.
as per a dictate, as per a mandate, they did not go. It is you can't say that is voluntary because you could not go.
No,
That is why you had to go to the court. Somebody wanted to go.
I agree with my learned friends. I agree with my learned friends.
Actually, yes.
One senior counsel who was appearing online, he said that. He said women in Kerala voluntarily don't go. He said it. We are not here to say you have to go. Anyone who voluntarily doesn't want to go has a right equally voluntarily not to go.
Voluntarily can
The
also
question
be
is, can there be a compulsion on me not to go? That's the question. Will that be invalid under 13?
voluntary may also be as a difference to the belief of what he or she
Yes.
is.
Whatever
Voluntary
be your
doesn't mean
reason.
that because it is totally my decision.
But I'm not disputing that. Whatever be your reason, you may believe he's a Naistic brahmachari. A woman will believe he's a Naistic brahmachari. I should not go. Please don't go. Nobody's saying you have to go. I'm talking about one woman who says, I want to go. The doctrine of de minimis does not apply to the Constitution of India. You can't tell me because you're just one woman who wants to go, I will not let you go.
Nobody's argument. That is nobody's argument.
It is the majority. The majority of the women don't want to go. They don't want to go, don't go.
That is one of the sides to just
There
purchase.
the question is whether the
That's not a
custom prevails or that one woman's desire prevails,
It's not a desire, it's a freedom.
or whatever.
It's not a desire. It's a freedom under 25(1). Yes, what will prevail? Yes, all right. Even if I agree with that formulation, answer it. You will then say, no, which principle of law? Which principle of law will you apply to this case? And say, for this reason, that custom is going to prevail. That's where Article 13 comes in. And I was amazed. Mr. Datar was invoking 13. All right, invoke it. I found a very good answer came from the Chief Justice. Mr. Datar, you mean to say that if a custom does not violate Part 3, it will continue? The answer is yes. It's a perfect formulation. Not all customs will go. It was put to Mr. Datar by the learned Chief Justice that is it your suggestion that if a custom does not violate any fundamental right, it will continue? The answer is yes, it will continue.
But then, yeah, how do you enforce it? When you enforce it, you will be getting,
Yes,
into,
now-
getting into the fundamental rights of the all others now. That is why my sister is saying, this process,
That is the clash of rights which
See,
Devaru addresses.
you are trying to,
So the answer to that,
see, you form your conscience, profess, practice and propagate, as against the person who already practice in propagating.
yes, yes.
Now, how does it going to this, then how do you trace it under 25(1)?
Yeah, that is where Devaru comes in.
Yes.
That is where the harmonization principle comes in. That is where the doctrine of essential practice comes in. Take it or leave it. Find another test. Which test will be found? Will you take this test of
25(1) is not against
hold that
25(1) is not against the rights of A as against B to D, Z. That is not under 25(1).
That is why I said, please, before deciding this case, decide what is the content of 25(1). It's a freedom. A freedom is different from a claim. I'm saying I'm a free person in this country. The only restrictions are me or what the Constitution puts on me.
But 25 is qualified by other part of
Yes,
the-
yes, it is.
So that is not.
Yes,
that
so it is, show me please which fundamental right I am violating by going in. Tell me, give me an answer.
The right of the majority who believe that it will be desecrated.
Right,
and
all right,
there.
if you are going to trump my right with majority, you're destroying my Article 21(1) right. Do it.
No, not because you're doing it, you have to assist us.
No, no, no.
I said do it.
I'm sorry.
Then we will do it, whatever we have to do, but then you have to assist us.
I'm sorry.
You're opening our mind.
It's my
You're opening our mind, convince us. Finish, as simple as that.
It's my mistake.
Oh,
What
it
I
was-
mean is that
it's
these
your
are
style,
rival
okay.
submissions. My lord, these are rival submissions only, your lordship.
Satisfy us, we are still open.
But I'm very glad I never ever became a judge. Very glad.
Yes, you don't even
I
know
don't want
what
the
is. what
onerous
is
burden of deciding these questions. But you have that onerous burden. I'm only saying don't avoid that burden. That's all my case.
It's not a burden, it's a responsibility. With the aid of the council, we discharge that responsibility.
Or has that confidence, has any judgment been not delivered? We decide. Have that confidence.
Yes, my lord. I'm saying,
And this is an important matter. Address us. We are freely asking questions also. It doesn't mean that it is what is their mind.
yes,
Then assist us.
yes, my lord. So just to be clear, we are discussing what is the width and ambit of the right under 25(1). I'm claiming a right under 25(1) to enter a public place of worship, if provided only that I'm a Hindu. I am also saying it's not important to me whether I'm a believer or not a believer, but I must go with Shraddha, with respect, to introspect. That's all there is to life, my lord. If we knew who we are, who said the only question in this world is who am I? There's only one question to be answered. If I had the answer to that question, I would not be in this court. I would be also a brahmachari sitting in a cave. You're then ready to renounce the world. Who amongst us can say that we have an answer to that question?
Oh, madam, that is why I told you, you go there, you said I go with reverence. Is it reverence that you know that I'm upsetting majority of the people there, but it is mine. Do you call that reverence? You said you go for introspection. Is it introspection?
Yes.
You have to answer some question. Oh, it is okay. Your introspection is that even if others are hurt, no matter what, I have to introspect in my own way. If that, then,
Question of-
well, it's the answer you have to give to us.
Legitimate hurt. Yes, the doctrine of hurt operates in the Constitution of India. The doctrine of hurt does operate in law, but it must be a legal injury that I'm causing to someone. You tell me what legal injury I caused to someone. If you show me the legal injury caused, I will not go. I'm saying both of us are claiming a legal right.
Madam, the only what my brother is saying, see, if you agree with your contention, it is going to lead to dangerous consequences. We'll tell you why. Really why. Supposing there is a common belief, followed by practice, profession, professing and propagating. Each one goes there and says, I don't want this. I want this particular way. Next person goes, I don't want this ritual. I don't want this practice. There is the end now. See, now, if you really look at it, if you give an interpretation like this, it will be disaster to the entire concept of the religion itself. And it will be militating against the very right given under 25(1). You really look at it that way.
It will
Today,
be-
now, if we say something like this,
It will be annihilation of religion,
Yes.
and which we don't want to be a part of.
All right. It will equally be an annihilation of religion if you
Yes.
give
What
every
are matters
temple.
of religion
Yes.
are what are matters of religion
Yes.
has to be given a broad meaning.
All right.
Broad meaning.
Yes.
We understand Article 25(2), which is the enabling power of the state.
Yes.
But otherwise, matters of religion are not a matter on which the court or the legislature can pass a judgment upon.
Yes.
Cannot be a subject matter of debate.
Yes.
Because it is a matter of conscience.
Yes.
And a matter of conscience cannot be a subject matter of debate before a secular
Can a
authority.
practice and custom be? I agree. My conscience can't be the matter of anybody's debate. Can anybody's practice which causes harm to be or not be? That is why you may be able
Because it is a matter of religion in that case, having regard to the philosophy of that idol, particular idol, the entry is banned for women between 10 and 50. It is a part of religion.
Okay, 1 minute. First, they have to prove that there is such a rule. Let's go step by step. First, they have to show me a theological text which says that. Okay. Not under 226, not under 32 in a properly constituted. Will they or will they not?
The custom.
Will they assume? Assume, then doctrine of in the Sabarimala case. This question. Who's supporting peace? And the court of law, the moment court of law gives recognition, it becomes subject to part 3. You don't recognize it. Let society do what they want to do. You give recognition to a particular thing, it becomes constitutional law. Now look at the reverse. What are they telling you? They are telling you, leave it to society to decide. And who is society? Society is the government of India. Why? 1 minute. This argument was seriously made. It was made, and I put it in my arguments. Majority. We are the will of the people is reflected in parliament. That was the argument.
Before social reform is required, the government, state legislature or parliament will step in. That much of power is enabled under the constitution. The constitution makers are very conscious of this fact that a matter of religion cannot be such that a social reform is also not permitted or entry is not permitted to depress classes, sections and classes of Hindus. Only with regard to Hindu religious institutions, not with regard to
other religions. No,
Yes.
that is why there's
Therefore,
so
the
much-
enabling
that is
provision.
why you have
That
experts
is
before you on Hindu law.
from saying create new rights.
So, and as far as you are, probably there's some misunderstanding. Mr. Tushar Mehta, the learned AG, gave us a categorical and that the government of India is the stand is that it will
Yes.
never interfere with any religion.
Yes, my lord.
Probably there's some
I suggest you
confusion.
take it in writing and make it part of your
I noted
judgment.
it down. Don't
Take
worry. He's made an open statement.
Yeah, a statement is not good enough. Take it in writing and make it part of your judgment.
But if there is a law which intrudes into religion, it will be the persons who claim that there is an intrusion who will challenge it.
Yes.
Not
They have the
anybody
right
who
to challenge.
says create a right.
They have a right to challenge it. They have a right to challenge it. That was the question raised by Justice Bagchi. He said, a dispute in a court of law is not a war. It is not. It's an ideological dispute in a court of law. I'm only giving you an alternative jurisprudence. That's all I'm doing over here. But ultimately, which jurisprudence to accept is your privilege.
No, absolutely right. You see, a new concept that you are developing, founded upon 25(1) and of course with the aid of 25(2). And undoubtedly will appreciate. All these questions are only, probably everybody is trying to understand more and more. That is there any confusion or created from this
I'll
side?
continue if you permit after 2.
Yes, yes.
I have put answers to some of these questions down in writing.
I think, subject to what you decide, Madam Indra, some of the parts of your written note, probably when you will read part of that.
Yes, I can give us.
Important points which you have highlighted.
Yes.
I think that will bring more clarity.
I will do that. I'll give a summary of that. And then I will take you to the statutory framework. We are done with the constitutional framework. We'll move to the statutory framework. Then, my lord, I owe one more correction now. If you can come to my written submissions, and I assure you that I will give you a summary. It's not here, but I will make the summary and give it to you. My lord, I also need, if you just look at the cause title on page 1, the 2 names are there. I did give you the names of the petitioners, Bindu and Kanakadurga. The names are correct. But, my lord, the first sentence, as was pointed out to me, I will make a correction if you permit me. Instead of putting it as these submissions are filed on behalf of 2 intervener when over the, I will change it to belonging to the Hindu religion. I will make that correction. They both belong to the Hindu religion.
That is what I was hinting.
I noticed, my lord, to be honest with you, yesterday we were sitting on my desk and Mr. Grover was the first person to point out to me, you made a mistake.
These are always inadvertent kind of
Yes.
things we don't check and.
So, I will correct it, my lord, for the time being. Please read it as both are Hindu. Now, as I've already told you about their climbing, you can change over that. I do not find a substitute for the word darshan, so I've said they went for darshan. What I mean by that is they went with reverence and respect to the temple after the judgment was delivered. The first and last time that they went, after that they have been actively obstructed from going there by violent mobs. And so they have not made a second attempt. Out of fear for their life and liberty, they have not made a second attempt. As I told you, one of them migrated to Delhi, although her parents left her free to do, and the other one faced victimization from her own parents. But that's not the subject matter of these proceedings. It's just a question of fact. So, my lord, if your lordship can come to, I've already told you the judgment is not. Now, my lord, this is critical for my understanding, and I hope it is of some assistance to you. The title is How Does One Read a Constitutional Text? I have already introduced the subject, and I will honestly quickly run through it because I know that you will read it on your own. So, but I will run through it to see if there are any questions arising which require clarity. So, now, my lord, we are talking about, this is actually written for 2 reasons which will emerge. The constitutional philosophy of India is contained in its preamble, in its directive principles and state policy. Ours is not a constitution without a philosophy, it has one. And the right. What is the promise of the constitution? The promise is liberty, equality, fraternity and dignity of the individual. My lord, it has a moral conscience. This is my formulation. The constitution has a moral conscience, is to realize these rights and values. In a society structured by wealth and power, the search for equality is a continuous one. So what I'm suggesting over here is the forms of inequality will keep emerging, new and new forms of equality will emerge. And just to give you one example, there is digital inequality, for example. But I want to tell you about something that was really heartbreaking. Your lordship knows the judgment of this court in Mathura, where this court held that the tribal woman had consented. Your lordship also knows how much that judgment has been criticized by scholars. Now, in a lecture, in a public lecture delivered in Delhi, on the Sunanda Bhandare platform, Justice Gawai said that this judgment represents the institutional failure of the court. For whatever reason, he said it. This inspired a journalist in Gadchiroli to go and meet her in Gadchiroli. He went there. And the story was published on the front page of the Times of India. Anyone can read it. And she said that my only companion in life for 50 years, the 50th anniversary of that judgment, has been humiliation. So he asked her why. Why is this so? You are entitled to benefits under the law. There are schemes for widows. She didn't have a living husband. There are schemes for women like you, old age pension. Why are you not availing of that? And she said, I don't know how to use digital devices. And because of that, zero. She was dependent on charity. She had a son who had abandoned her, and she did not want to depend on her son. So all I'm saying is there are new forms of inequality that will emerge as we move down the road. So inequality is not frozen in time. You will face these challenges. Somebody will file a petition. What about digital inequality? Will you declare it a violation of Article 14 and 15? You will have to. So this is what I'm saying over here. That is more the case in India, which has historical roots of inequality structured by caste, class, and notions of patriarchy. This is what Article 15.1 wanted to dismantle. Article 15.1, 17, and 21 dismantle this structure. So this is how to read a constitutional document. Generations to come will aspire to correct inequalities and injustice, to uphold the dignity of human beings in a changing society. Just to pause here, this court has done it. This court has declared, overruled Eke Gopalan, overruled in the sense departed from that jurisprudence and said rights don't function in silos. You have to read them all together. That is Maneka Gandhi's case. And Rustam, these are those cases which deal with that. And why? To meet new challenges. Then this court has used the concept of manifest arbitrariness. Why? To meet the challenges of an evolving society. There are inequalities which our constitution makers did not visualize when they made the constitution, but a constitutional document is written for you, for the courts to elucidate what exactly is the content of the right to equality, whichever way you look at it. So that is what I'm saying over here. The constitution is a grundnorm in the Kelsonian sense. This means it is the highest norm in the hierarchy of norms, and all else, including culture and religious, must yield to this norm. This is my respectful submission. There is no norm higher than the constitutional norm in this country. And so therefore, this will have to be addressed while addressing the question of religion. Of course, this court has declared the basic features of the constitution, and there is academic debate whether that's a meta norm or whether it's a norm or whether it's something which grows out of the constitution. But for my purposes, it's enough to say that the constitution is the grundnorm. And everything else, administrative, legislative, custom, practice, has to be judged against this grundnorm. The moral conscience of the constitution is redeemed by the judiciary. Now, I have put this in because I perceived the arguments of the other side to mean no judicial review in matters of religion. I'm trying to counter that argument. The moral conscience of the Constitution is redeemed by the judiciary through judicial review, expressly contained in the text of Article 26 and 32, and through the adjudicatory powers of the courts. It is for this reason that Ambedkar called it 32. The heart, I've already said, not because he wanted all of us to file petitions over here, but that access to justice is what he was talking about. That is what makes it a living constitution. Otherwise, it would be a dead letter. The legitimacy of the Indian constitution is derived from its normative values. This court has talked about legitimacy of the constitution in its judgments, which I will show you. The judiciary is the counter-majoritarian institution that protects the rights of minorities, discrete or insular. That is why I said the doctrine of de minimis doesn't apply to the Constitution of India. Rights of minorities, discrete or insular, against majoritarian notions of morality. It is for this reason that the word morality, wherever it occurs, must be read as constitutional morality. Simple, but not straightforward. I don't claim anything in constitutional morality beyond this. Constitutional morality narrows down the vagueness of the word morality and limits it to the morality of the preamble, the fundamental rights and directive principles of state policy. In every judgment dealing with constitutional morality, the court has said this, that we actually draw our power from the preamble, from the fundamental rights and the directive principles of state policy, because they call this the morality of the Constitution. They have never struck down, to the best of my knowledge. We need not have an empty debate. To the best of my knowledge, no law has been struck down on the ground of constitutional morality. Maybe in the future, I don't know. I don't wish to address that issue. But in every case in which it has been invoked, it has been very clearly pegged on to some fundamental right, some directive principle, or the preamble. Dignity is coming from the preamble. Dignity has been declared to be a fundamental right. Yes, in Buddhaswami. I've quoted it. The judiciary, I've already read that, it narrows down. So please remember this. We are not asking for constitutional morality to go beyond the confines of the Constitution itself. And now, this is very important. India has no separate courts resolving disputes of a religious nature. This is the case in other countries. You have them in Pakistan, you might even have them in Bangladesh. We don't have. We don't have Sharia courts, we don't have ecclesiastical courts, we don't have courts of Hindu law. We have only one single hierarchical system of courts, up to the Supreme Court. Now, in this situation, you can't shut out anyone who brings a bona fide dispute to you relating to Hindus and Muslims. All disputes relating to personal law were decided by the courts by applying Hindu law to disputes relating to Hindus and Muslim law to all disputes relating to Muslims. It is impermissible to raise a contention that Indian courts cannot adjudicate disputes relating to religion. They have been doing so since the commencement of the modern legal system, which goes back 2 centuries. I'll point that out. Whenever courts in India were unaware of religious law, expert evidence was taken, and expert evidence is admissible in relation to issues involving a religious character. Now we come to the next doctrine of living tree, which has been used by this court. The role of the courts is to protect the moral conscience of the Constitution by enforcing constitutional norms and its basic structure. This requires the court to interpret the Constitution as a living document with the current aspirations of individuals and to protect the rights of insular and discrete minorities. The Constitution of India is not a static text, frozen at the moment of its adoption. It is a living document which must be interpreted consistently with the constitutional philosophy of justice, equality, liberty, dignity, and fraternity in a manner that gives effect to the transformative aspirations in respect of changing social realities. All that is meant by transformation is you are going from a country without a constitution, without fundamental rights, to a country which gives you fundamental rights. That is the transformation. We never had fundamental rights. We were not considered citizens until the Constitution came into force. Subjects. Indians were subjects. There was no question of any fundamental rights. It comes for the first time with the adoption of the Constitution of India. And that is why the doctrine of transformation. It is a living document that must be interpreted consistently with the constitutional philosophy of justice, equality, liberty, dignity, and fraternity in a manner that gives effect to the transformative aspirations and response to changing social realities. The principle has been affirmed by this Honorable Court across a long line of decisions. Yes, let me go to Buddhaswami because dignity. And when I was arguing for the first time in this court, I was arguing on behalf of the pavement dwellers of Bombay. It's known as the Olga Tellis case, reported judgment. I wanted the court to read into Article 21 the right to livelihood. And it was done by this court. On this doctrine, of living tree. You have to deal, you have come to the court with a challenge. You're telling me that pavement dwellers have a right to housing. How do I resolve this issue? So this is the only way. Similarly, in Puttaswamy, writing for the 9-judge constitution bench held that constitutional guarantees must be read expansively, having regard to the dignity and autonomy of individuals, and that an interpretation which confers a constitutional provision to the narrow social assumptions of an earlier era does so at the cost of transformation, constitutional transformation. Now the court, dignity cannot exist without privacy. Both reside within the inalienable values of life, liberty, and freedom, which the Constitution has recognized. Privacy is the ultimate expression of the sanctity of the individual. It is a constitutional value which straddles across the spectrum of fundamental rights and protects for the individual a zone of choice and self-determination. This might even answer the question of what is conscience. It is self-determination. It is a zone of privacy. Some of the submissions in this court I have read, and some of them have taken the view that conscience is part of the right to privacy. Because you can't sit in judgment over somebody's conscience. Yeah. Now, there's a very interesting and important quote from Nalsa. This honorable court reaffirmed that the Constitution must be interpreted to fulfill its higher purpose, and that a textual and originalist approach is inadequate when the Constitution is designed to endure for ages. Quote, the interpretation is in consonance with new social needs. By doing so, this court is only bridging the gap between the law and life. And that is the primary role of the court in a democracy. The word democracy is very, very important. This formulation that all that is necessary in a democratic society is there in the European Convention on Human Rights. And I have found it also in one of the judgments of the court when they talk about the doctrine of proportionality. So what is the touchstone against which you will judge proportionality? On the question, what is necessary in a democratic society? Then you will decide the issue. And I'll point out, that's why the word democracy is used here. It only amounts to giving purposive interpretation. My Lord, your Lordship have done purposive interpretation multiple times to the aforesaid provisions for the Constitution so that it can adapt to the changes in reality. Now, this is a very, if I may say so, very beautiful sentence. Law without purpose has no raison d'etre. The purpose of law is the evolution of a happy society. It speaks for itself. I don't need to comment on it. Yeah. Then, my Lord, I've given the origin of this theory of living tree. It was first articulated in Canada in Edwards versus Canada as follows: a living tree capable of growth and expansion within its natural limits. Now, the words natural limits appear to be qualifying how far you can go in interpreting the Constitution. So they have likened it to a tree which keeps growing to its natural limits. That is the meaning of how to interpret the fundamental rights. Holding that it must be capable of developments to meet new social, political, and historical realities, often unimagined by the framers. Then, Your Lordship may skip over the case law, but there is one judgment. Give me the side now, please. This court has made a reference in Central Board of Dauda Boris. It's reported in 2023, 4 Supreme Court cases, 541. A bench of five judges, Justice Sanjeev Khanna, Sanjeev Kishan Kaul, Sanjeev Khanna, Abhay Oka, Vikram Nath, and Maheshwari. 2023 4 SCC 541. Now, they did not decide this case. They said a reference is pending here, so we will wait till this order comes, and then we will decide this case. And if you turn to it, the issue here was untouchability. Social ostracism. Now, you can just straight away turn to
Excommunication.
yes, excommunication, which is also, it's also a case before you. It's one of the, Mr. Ramachandran is appearing in that case. Yeah, excommunication. But they didn't decide it. They said this reference is pending, so we won't decide it. But you see the reference to a living tree at page 554. And one more reference which I wish to read out. There is a reference to a living tree, take it up. There are two reasons why I want to read this. One is Justice Oka, who wrote for the court, refers to the doctrine of living tree, but he says, I cannot decide because this reference is pending. And secondly, Your Ladyship, at page 555, there is a reference to Central Inland Water Transport versus Bijoynath Ganguly. This, I must say, it's one of my favorite cases, but we will read it at page 553. And the proposition that I'm making of the judgment, the proposition that I'm making here is that even in the realm of private law, that is contract law, when the question was, what is the interpretation to be given to the words public policy in section 23 of the Contract Act? They used constitutional principles to advance the philosophy of the Constitution. So that is quoted at page 555, para 27. In para 26 of the decision, this court in Central Inland Water said as follows: the law exists to serve the needs of the society which is governed by it. If the law is to play its allotted role of serving the needs of society, it must reflect the ideas and ideologies that at page 555. It must reflect the ideas and ideologies of that society. It must keep time with the heartbeats of society and with the needs and aspirations of the people. As the society changes, the law cannot remain immutable. The early 19th century essayist and wit Sidney Smith said, quote, when I hear any man talk of an unattainable law, unalterable law, I am convinced that he is an unalterable fool. Quote, close quote. The law must therefore, in a changing society, march in tune with the changing ideas and ideologies. Legislations are, however, not best fitted for the role of adapting the law to the necessities of the time. For the legislative process is too slow and the legislation often divided by politics, slowed down by the periodic elections and overburdened with the myriad other legislative activities. A constitutional document is even less suited for the task, for the philosophy and the ideologies underlying it must of necessity be expressed in broad and general terms, and the process of amending the Constitution is too cumbersome and the time consuming to meet the immediate needs. This task must therefore of necessity fall upon the courts, because the courts can, for the purpose of judicial interpretation, adapt the law to suit the needs of society. Simple proposition. And ultimately, my lord, what this court did in Baidyanath Ganguly, they invalidated a rule which was described as the Henry VIII clause, because it was the rule of hire and fire. The rule said that you can be terminated without natural justice.
It was an unconscionable condition of the contract.
Yes, yes. So something which could not otherwise be done under common law, but by in.
Yes. That is why it was said. Justice Madan.
Find the living tree. Find the living tree. So, well, not for two purposes only I'm reading this. It cannot be suggested that what can be done in the realm of private law cannot be done in the realm of public law. There is a reference here, Lord, I'm unable to find it. Para 25. Well, not para 25. If you see just the beginning, first 1 or 2 pages, approach to be adopted. While interpreting the Constitution provisions, we must remember that the Constitution is a living instrument. That's all I wanted to point out. So the doctrine of living tree is not something that we are inventing. And the doctrine of constitutional morality is not something that we are inventing. On the contrary, we are giving to the word morality a certain meaning. That's it. And in my submission, this actually cuts down the subjectivity of what is morality. Otherwise, you can give it any subjective decision. So I do not accept the proposition that morality means public morality. No, because the public can be, they can be full of prejudices. So, and Mr. Learned Solicitor went to the extent for saying that the legislature alone decides what is public morality, which is reflected in your laws. If that was the case, why would you have doctrine of judicial review? Accept it and go home. But no, the Constitution said what you think is public morality and you're putting in law, we will decide whether it is constitutional or unconstitutional. So that's all I'm saying. It's the approach to judicial review that has been adopted, my lord, to say, to put it mildly, it's not fair to the court. It's not a doctrine that should have been attacked with so much vigor. That is all I'm saying. You can have a difference of opinion on how far you can go, but this was a wholesale. You leave it to the legislature. You can't leave it to the legislature to decide what is constitutional and what is unconstitutional. That's how I understood the argument. Now, my lord, if your lordship comes straight to 3.1 at page 7. As I said, these submissions are confined only to the question of temple entry. My lord, I am not in a position to deal with abstract issues, but I can tell you that you are going to be called upon to decide the following questions. Let's take the case of female genital mutilation. There is an organization which is claiming that in exercise of their power of religion, protected by 1 Red Pit 26, they have the power to perform female genital mutilation on girl childs who are about 7 years of age. This court is called upon to decide the constitutional validity. Is that something which is part of religion or not? Even if it is, let me go to the extent of saying it is. Are you going to give constitutional sanctity to it? Or will you say, no, you cannot mutilate a child's body? And this is in the name of religion. Now, I want to link this to an argument which I made in the morning about custom and usage. All right, I'll do it as we proceed. It's here. What happens? Why has this court used the word in its judgment, egregious violations? It is there as a limitation on the right to religion. In judgments of this court, it is there. Why? And the other side is conceding that, yes, this is the limitation. Why? If your right to religion is unlimited, as you claim autonomy, on what basis are you saying that egregious customs are out? So I will develop this argument a little later, but for the moment, just keep this in mind, that you have FGM before you. Secondly, you have social boycott before you. There is a petition claiming social boycott. Thirdly, there is a petition which says that if a Parsi woman marries a non-Parsi, she cannot attend her father's funeral, which takes place inside an agyari. Now, my lord, that petition was argued by me. Today, it is going to be argued before you by my learned friend, Mr. Darius Kambata, and I will be assisting him in the matter. But at the interim stage, Mr. Gopal Subramaniam was appearing. In fact, even now he is appearing in that very matter, in the Parsi woman matter. And at the time when the petition came for hearing, her father was 89 years of age. By the grace of God, he is still alive. Okay. When the petition was heard, he was 89 years of age. And Justice Deepak Mitra turned to Gopal Subramaniam and said, Mr. Subramaniam, are you going to allow this woman to attend her father's funeral or not? And Mr. Subramaniam, to be fair to him, had a statement recorded in court that yes, we will allow her to attend her father's funeral. Okay? So on what basis? Okay? Will you allow them to claim this as a right of religion? This, in fact, that case is a very important case. For what reason? Because They said to her, you don't belong to the Parsi community, therefore you're out. Why don't I belong to the Parsi community? Because I married a non-Parsi. Well, your lordship knows, in today's world, Parsis are a diminishing community. They all marry non-Parsi. But the court said, the High Court said, if a Parsi woman marries a non-Parsi, she ceases to be a Parsi. How? I have not renounced my religion. I married under the Special Marriages Act. I kept my religion intact. My husband has his own religion. He's a Hindu. I can give you any number of examples of intercaste marriages where the wife keeps her religion, the husband keeps his religion. They don't convert. They keep their respective religions. In such a situation, the Gujarat High Court said, no, the minute a woman marries a non-Parsi, she becomes a non-Parsi. So the Parsi woman has become a non-Parsi. It's a deemed conversion. Okay. From where? That again, your conversion laws come into the picture. It is nothing but the doctrine of kavacha, again, which exists in common law, that upon marriage, a woman's identity is merged with that of the husband. That is the view. Doesn't matter. That came by way of a 136, it's pending before you. And it's part of this group. So he will be addressing, I will be assisting him. And that is the matter which Gopal was kind enough to make that submission. And that is the interim order of the court. It is in continuation. And as I said, by the grace of God, look at me, my Lord, in the temple of justice, I'm invoking God. But by the grace of God, he's alive today, her father. But the question will arise when he dies, whether she's going to be, she filed a petition before his death, apprehending that I will not be allowed. And she's not the only one. There are many Parsi.
Probably there the question would be, we don't know, we have not heard, whether a woman can be discriminated against or simply because of her marriage.
Yes.
Marriage is the basis of classification there. So it can be a basis of classification. Whether marriage for a woman can be a basis of discrimination is the question there.
I'm losing my
That
status.
question is quite different from the Sabarimala.
But please just hear me on this. It's also a question of status. My status of being a Parsi is being taken away from me. I'm being told because you married a Hindu, you became a Hindu. How? How do I become a Hindu just by marrying a Hindu? How do I lose my religion, forget my femininity? It was a loss of religion on marriage. So the High Court said, never mind, I'm just giving you the range of issues that are pending before you.
Basically, what you're trying to say is that because I have married somebody, you can't decide and give a judgment on me that I have changed my religion. That is my belief. You can't take a stand that my religion has changed.
Correct. That everything else remains the same. But I want to continue being a Parsi.
You can't decide for me that what
is my religion? Yes. There's nothing like deemed conversion into another religion. It's a very important issue. It will come up again in your group of conversion petitions. Never mind. I have filed my written submissions there. As and when that matter comes up, we will address it. That what is the meaning of conversion? Okay. And what is the distinction?
That is why facts also have become important in these cases. Because they can't just decide in the abstract. They cannot be a straight jacket.
Yes, it's the issue involved.
Issue has to be.
Issue involved in each controversy we should know.
Yes, my Lord, I'm sure we can assist you. We'll give you a short note on each of the petitions. What are the issues involved? That's not a problem. But broadly speaking, I'm trying to indicate what are the issues involved in the petitions before you. In the I have taken a stand in my written submissions, which are already filed in the anti-conversion cases which are before you, that actually conversion is ceremonial. It's the act. Before you convert, your act of conscience, you adopt another religion. It's an act of conscience. There's a separation between your act of conscience and your act of ceremonial acceptance. Before I become a Muslim, I may be asked to swear allegiance to the Quran, I'll do it. But before I've done it, my conscience has told me, you please adopt this religion, it's better for you. Or you want it.
What happens to a Parsi man if he marries?
He doesn't lose his religion.
He doesn't. So the distinction, Mr. Jaising, is on gender.
It is.
So the classification is gender perceived.
It is gender perceived, but it's also results
Like
in loss
intersections. Unlike the other cases of intersectional, discrimination of parts of
Yes.
the gender.
I lose two rights. I also lose my right of religion simultaneously. Both rights are gone.
So the classification in the Parsi case is clearly on gender.
Because they are going on the doctrine of kavacha in common law, that upon marriage, a woman's identity.
That answer is given in Joseph's Shrine.
Yes, it is. It
Answer
is.
given in Joseph's.
It is, my
If
lord.
we uphold Joseph's Shrine,
Yes.
this restriction must go.
Yes, and the only criticism of Joseph Stein was what? It was constitutional morality. No other criticism of Stein, because it was pointed out that the issue of adultery was gender specific. It was gender specific.
That is,
It was
Joseph
not
Stein was
applicable equally to men and women.
not, it was more on Article 21 and 40
Yes,
and not on
Yes.
constitutional morality
It
as
was
a
not.
general principle.
yes, not. It was not. But an impression was conveyed to you that it was on constitutional morality. It was not. It was struck down on gender discrimination, that you are doing this to women but not to men.
We have also given one more judgment, old settlers in Sikkim, that if a Sikkim woman marries a non-Sikkimese, she loses her income tax exemption.
Yes, yes.
Otherwise, if all Sikkimese have income tax exemption, but if a Sikkimese woman marries a non-Sikkimese, he loses that. So there we have.
It's again a reported judgment, and these are the different situations in which it will come up in the anti-conversion laws as well. So I will give you a short note on the how the issue will come on anti-conversion. I am very clear in my mind, conversion is the wrong word to use. I adopt a new religion. I'm adopting a religion other than my own religion as an act of conscience. Then I go through the ceremonial, which is required to confirm that I am for the outside world. That is why marriage is, religion is a matter of status. When I say religion is a matter of status, I mean I am identified as belonging to a particular religion. That's it. And the whole world has to say that I'm a Hindu. The whole world can't say anything other than that, because now I want to add another dimension for you to think about. Religion is inherited at birth. I have no control over it. I take the religion of my parents in law. In law. It is only when I reach the age of 18 then I can decide whether I want to remain in this religion or whether I want to exit this religion. Otherwise, how do I get my religion? मेरे विरासत में आई है. I got it when I was born. In law, because of the concept of guardianship and because of the concept of custody of children, you take the religion of your parents. And if you want to argue to the contrary, you have to prove that you have been brought up in a different religion. Then the court will ask for evidence. Were you brought up as a Buddhist? Were you brought up as a Parsi? Were you brought up in which way? I want to just give you one more example of the cases that are coming before you. Now, if you accept this doctrine of merger or non-discrimination, the marital rape case is pending before you, my lord. The marital exemption is pending. And what is the argument over there? The argument over there is this is discrimination. Multiple arguments. I have put another argument which is not based on discrimination. It's based on what do you mean by marriage? Marriage is an institution of equality. Husband and wife must necessarily equally respect each other. Otherwise, what is marriage? It's affection. What else is it? So, and then, but use the doctrine of kavacha, and you say that when you married, you're deemed to have given your consent to sexual relations with your husband, whether you like it or you don't like it. That's your marital rape. Again, that case will be covered by this. Or the discrimination issue. The government of India is justifying that law in court. The Delhi High Court has split on it. One judge said it violates all the provisions of the constitution. The other judge says it does not. Anyway, I'm not here to argue that case. I will do it as and when the matter comes on board. It is here, pending here. And my case is even more complicated because the woman who has come to court went to the High Court in Karnataka, and she is a woman who, under the existing law, is saying, I've been raped without challenging the constitutional validity of the law. She's saying, even as it stands, I cannot be raped by my husband. And the High Court accepted that argument. But we have to see now where this case is going, how it will go. So I can tell you in my own opinion, my lord, and history has proved it, not will prove it, the really difficult cases which are going to come to this court. You take the last 10 years. Somebody wrote a book, 10 most important cases of the Supreme Court. I don't agree. I can't say I don't agree. They are important cases and no, not important. But if someone was to write a book, 10 most important cases of the Supreme Court in the last decade, gender will come right into the forefront. What was Nalsa? What was Navtej Tagore? Navtej? Every case that has come before you in the last 10 years has been a case of gender justice, and so is this one. So this court has a, let me say difficult, I don't want to say difficult task, it's not difficult for me, but it's a task. These are issues of the future. They are going to continue to come to court. So it's best, my lord, that your lordships have a judicial approach to the question. It's not going to decide only these cases. I will continue, my lord. Now, my lord, this troubling question also of the nature of the right. I take the view it's an individual right. 25. Individual versus group rights. Now, my lord, I'm asking the question, if there was no 25(1), would there be 26(2), 26B? 26B is inextricably linked to 25. 1, 2, A and B. Without 25, you can't have 26. It is actually part of the right under 21. Now, how much is a part, how much is not a part is a different issue. But there's no doubt about the fact and if there was no 26, does it follow that you can't form an association? You can. It doesn't follow that you can't. You've got Article 19, under which you can form a trust. You can form an association. You can form a charitable and a religious association. So therefore, my lord, it is incumbent upon us to understand why
The charter, madam, charter of that association will be a subordinated rules to all fundamental rights. When it is a denomination, the charter, to the extent it relates to matters of religion, is elevated to a fundamental right status.
it is.
Not subordinated to the status of equality and other freedoms. So that is the respect we have to give to religious denomination and their matters of religion.
You cannot read one without the other without the other. They are twins.
Because some argument was made that we read 26 denomination along with 19(1)
Yes.
E, that is right to form association.
Yes.
Right to form association, when you see the religious denominational right, the association right is protected,
Yes.
but the rules of the association are not protected. When you see a denomination, the denomination is not only protected, the rules relating to matters of religion of the religious institution which it establishes and maintains
Yes.
is a fundamental right.
It is.
So
It is.
that respect and that reverence to that right,
Has to be given.
co-equal with the right of 19, 15,
Yes.
and 14 has to
Yes,
be
my lord, but
interpreted.
you have to answer the question, at least in your own mind, why is that respect given? Why is a denomination so respected? We must understand that. Why is it? Unfortunately, as I told you, in the Constituent Assembly, only 4 days this issue was debated.
And this is where the deference argument has been advanced. That when we see this, until and unless the courts are hard pressed to decide the rights, we will not tread into it, defer to the constitutional scheme of legislative intervention through the state. That is 25B.
Yes, it is there. 25B immunizes any law if it is passed. They cannot say it's unconstitutional because the endowment is given in 25(2)B. How can they say that if the state makes a law, how will they argue it violates fundamental rights? It is itself a fundamental right. So there is an endowment. I don't dispute the fact that there is an endowment in 25(2)B to make laws. But does it mean that if, let me tell you, even this and controversy at the end of the day may be purely academic. The reason being, almost every state in India has made temple entry laws. Let me put it bluntly. Let us be real about this case. We are arguing it as if I'm on a clean slate. I'm not. Every state in India has made temple entry laws today. So today, if I would not be having to make these submissions, if I wanted to claim a right, I can go under the statute. And I will say that statute is immunized by.
Yes, this is the exact situation where the exercise of Article 32 powers coming or 226 powers coming. Every state has made a law articulating its constitutional powers
Yes.
under 25(2)B in respect of Hindu temples.
Yes, yes.
But there is no such law in respect of non-Hindu religious institutions.
Yes, it's.
Can the court, in its zeal of maintaining equality and equality of status, enforce such direction in respect of non-Hindu institutions?
Yes,
Or
but,
it should defer to the legislative wisdom?
these questions have come up.
If we did that, then by now, the courts repeatedly requesting the state for uniform civil code would have made incremental interventions in that area.
Yes, yes. And the validity of, let's be clear. India, why was UCC put in the directive principles of state policy and not enacted as a law? There's a policy decision behind it, right? It's a policy. The UCC has been put in the directive principles of state policy. India does not have an all India UCC. We don't have it. But we do have an All India Hindu Marriage Act. We do have an All India Hindu Adoption and Guardianship Act. We do have a Hindu Succession Act. We have it. This is a policy decision the government of India has taken. They are free to change their policy decision whenever they want to. This is a decision taken from British times that we will not intervene in the affairs of a community if the community doesn't want it. Fair enough. I am not saying, but if they do make a UCC, you might have to declare the constitutional validity of it. He was not able to answer that question. That question came from the bench. How will you justify a UCC? The only answer was you can do it. All right, why can I do it? Why can I do it and not in any other case? But this is it. Yes, it's a policy decision of the Constitution to keep UCC in directive principles of state policy, but there's an endowment to the government to create one if they want to. They have not done it so far.
So the society, if it is ready for it, it
Yes.
will be done. Now
That
it
is
is
the
coming
decision. To
statewise.
that extent, they are free.
Now it is coming statewise.
Yes. No, I'll tell you the reason why. Yes.
The parliament finds
Yes.
that it can be done applicable throughout the country, then the time will come.
Now,
Therefore, it is in the directive principle.
yes, let it be. I am not resisting any UCC. As and when it comes, whoever wants to challenge it will challenge it on any ground. But one of the reasons why it's coming state-wise is because the legislative entry of religion is in the concurrent list.
Yes.
All right. Concurrent means both can make. But if you see the
Madam,
pattern of legislation in India, it's state-wise.
My question to you is not UCC in what form it is brought. In what form it is brought will be naturally examined when it is brought. But you see the constitutional aspiration of an UCC in the directive principles of state policy is admitted. And the social reforms understood
Yes.
in 25B,
Yes.
in my interpretation, has to be linked with the constitutional aspiration in the directive principles of state policy, that the state, through its social reform legislation,
Yes.
25B,
Yes.
will bring in an uniform civil code for the country.
Yes.
my question to you is, if the state fails to do it, is it within the ambit of the judiciary to exercise its powers under 32 and 26 to bring in
No.
incremental equality clauses in
Answer is no,
various
but
nations?
my answer
Today,
is,
you are talking of penal legislation, and there it's a different thing because the penal legislation has to, it's a secular legislation in Joseph's sign. When it comes to religious freedom
Yes.
and protection of a fundamental right in matters of religion,
yes,
can we apply the tests of equality to that extent that we completely negate a practice, admittedly, as you say, of a integral religious practice of a denomination? Or we have
not
to defer to the wisdom of the
integral
legislature.
practice. I said you leave out rituals. You can't change, no court can change rituals. Leave it out. But I did not say integral, but I want to answer the question.
It is, this will be the question which may be argued by Mr. Subramaniam in the Parsi.
Yes,
case.
yes.
That the woman
But if
cannot.
I'm capable of dealing with it, I will sit quietly by his side and assist him.
Sir, don't, you may make your submissions when.
Yeah. Yeah, but to answer the question of incremental change, that was also the question. The answer is no. Let me say this. I challenge Section 6 of the Hindu Minority and Guardianship Act, which said the father is the natural guardian. I said this is facial discrimination. This court, I'm using a colloquial word, it's not a legal word. In my opinion, they dodged the answer to the question. They did not decide on the constitutional validity of Section 6. What they said is, they interpreted the word in his absence. The section says, the father is the natural guardian, in his absence, the mother. Okay? Now, what the court said, in his absence doesn't mean when he dies. They said, if he neglects. Okay? Why? Because the court didn't want to answer the question whether it's facially unconstitutional. In my opinion, it was facially unconstitutional. Never mind. I'll give you another example. I argued the Mary Roy case. All right. Now, on facially, the section says a woman will be entitled to 5,000 rupees and the rest of the estate will go to the son. Now, this is a Syrian Christian community which has acres and acres of land which are to be inherited. Okay. Now, again, I thought it's a cakewalk for me. I'll close my book and go home. The court is going to declare this unconstitutional. What did the court do? The court said, here, court one. The court said, no, this was a Part B state. And when it became a full state, that Travancore Christian law got automatically repealed and the Indian Succession Act applies where you get equality. So again, I could not get an answer to the question whether a facially discriminatory law can be struck down by the court. And mind you, this was statutory law. It was not custom and usage. It might have the only sole exception where the court has done it is the Saira Banu case. So there they asked the question. And why did they do it? Justice Nariman, who, by the way, what your lordship knows, he's himself an ordained priest. He was on the bench. And he has asked very tough questions. How can we do this, he said. Now, I pointed to the Sharia Act of 1939, which imported uncodified Sharia law. It just said the rule of decision by the courts will be the Sharia. It didn't tell you what is the Sharia. Well, I was answering your question also. How do we know what is the Sharia? There can be disputes. But there have been disputes among scholars, theologians. I can't give you an answer. I can't give you a theological answer. A theologian can answer that question you put to me. And the distinction between Hindu law and Muslim law is that it allows theologians to interpret the law. That is the difference. When there's a doubt, Muslim law is resolved by opinio juris. It's a well-known concept in international law. Opinio juris is a source of law. So the opinions of theologians is a source of Muslim law. And that is how they do it.
But in that case, it was 3:2. 3:2.
Yes.
And ultimately, the parliament took a cue from the minority
Yes,
opinion and then passed
that
the law.
Mr. Tushar Mehta has to answer. I don't have to answer that question.
They accepted the minority opinion and acted upon it.
Yes, my lord. Your lordship may ask him when the time comes for rejoinder, because we opposed it. We said, don't do it. And we said, let it be. There's a judgment of the court. Let the judgment of the court operate. But it's done. I think it's already under challenge, somewhere pending in some court. It is there. It is under challenge, isn't it?
The judgment could not have, you see, given also the penalty for it. But
Yes.
the law has given it.
Not only a penalty, but until the women of the country made a big hangama about it, it allowed a third party to file a complaint. Then we said, how can you, the whole locus issue. Then we said, how can you do this? How can you allow a bystander to come and question my marriage or to question my divorce? Then they changed it. Then the government of India had to change that law and remove that clause which says that anyone can make a complaint. So my purpose here is to just alert you to the fact that you have multiple issues before you. Yes, Lord, I'll just quickly proceed. The crux of this portion, my Lord, I would certainly like to finish so that others get a chance. And I will certainly try to finish before the day is out. Because I will take it that my submissions will be read, so I'll focus only on the important ones which I think require an answer. So, my Lord, we'll skip over this. I am saying that the Constitution of India.
Please have some water. I think you were to drink water, but you stopped. So please have some water.
I also want to ration my time. Normally, I don't take this long, but I will finish. And I will take my submissions as read. For the moment, I'm only making a submission. The Indian Constitution was written for individuals. It was written for sentient human beings. Even if I'm one woman, I'm a sentient human being. I have a conscience. It was written for me. It was not written for groups. This is my submission. Then, my Lord, secondly, just make a note. It is my submission that the Constitution governs from birth to death. It doesn't govern before birth. It doesn't govern after death. Constitution of India. And religion may govern before birth and before death. But as far as this constitutional code, so the question is the right to religion guaranteed under the Constitution or outside the Constitution? That's why the Granular. From where is the guarantee coming? It's coming from the Constitution. Of course, as Justice Nagaratna put to me, it's an inborn human right. It's an international, I'll skip over that portion. It is an international human right. If you come to page 12, I will not make you read it, but all I need you to note is that it's part of ICCPR. Now, what is the significance of ICCPR? It is a civil and political right, immediately enforceable, and rights from which there can be no derogation. That is known as a civil and political right. It's at page 12. That's why I kept saying, please, let us answer the question, what is the nature of this right? And India has put it in its constitution in terms which are similar to international law. My Lord, I just want to quickly just make one or two comments on when I said it's a right in rem, what did I mean? I meant it's available against the world at large. I also meant that no one can take it away from me. Only I can renounce it. No one else can take away this right. You can't take away my status as a Hindu from me. You can't take away my status as a Muslim. You can't take away my status as a Parsi. That's the meaning of a right in rem. So, so therefore, my Lord, if I am a Hindu, now, my Lord, I want to come quickly only to page 18. I do wish to show you that.
What is the relevance, madam, with right to rem, your religion? Who's taking away the religion?
I just gave you the example of the Parsi woman, her religion was taken away.
You'll argue for that.
Yes, yes.
But then what, as a general principle, how is religion? Nobody is.
My Lord, I'll tell you the relevance.
Back on religion that you can't.
All right. All right, let me explain the relevance. The relevance is, it's my choice. The relevance is when I want to convert. That's the relevance, okay? I am saying I don't agree with the tenets of Hinduism. I want to become a Muslim. Ambedkar said it. He said, I was born a Hindu, I won't die one. Right? It becomes relevant there.
There's no controversy on that, but there's
There's-
controversy on that.
The,
What was the,
It's
what, what will be the ramifications? Case to case, we may say, what would be the, whether after I take a decision, then the new right of being in another religion, whether that can be given to me in full and I should not suffer just because I've shifted religion.
no,
That will depend on
no,
the case.
the relevance is I will have to follow all the tenets of the religion. All the ceremonies will have to be gone through. I will have to take an oath of, on that religion. I will have to go through all the ceremonies and I will have to observe that relevance, that religion. That is my relevance for me.
But that is for the new religion.
New. I'm talking about new. I'm talking, that's an act of conscience. All I'm saying is it's an act of conscience. I don't want to say anything more than that. I'm only saying my conscience tells me which religion I should adopt, but I can do this only after I attain the age of 18. Before that, I can't do it.
Again, there's a slight contradiction. You move from one religion to another religion, perfectly fine, nothing to do with it. But you say, no, the religion I have left, in that religion, that provision is not correct. You are not in that religion.
No, I don't want to get into that. I'm not saying that. I'm not saying it. I'm only saying my conscience tells me to leave this religion and adopt another religion. That's all.
Put the question first, you cited that
For
example.
this issue, Mr. Khambata will,
Right, exactly.
we will hear Mr. Khambata in detail on.
Yeah, well, I want now. I'm actually going to focus on this page 18, and then I will leave you to read the rest of the document because for me this is an important argument. It is at page 18. Now there is the question of untouchability. What I have done is very simply put down the drafting history of 17. That's all. Nothing more, nothing less. Let us see the drafting history. Article 17 is not confined to untouchability of the scheduled caste alone, but includes all forms of untouchability. All right, on the plain language, it says all forms of untouchability. I don't have to stress you on that. Now let's see the drafting history. The exclusion of women from places of worship on biological or physiological grounds inherited at birth amounts to a violation of Article 17, since they are based on notions of pollution and purity and defilement. Let me stop here. 3 words, pollution, purity, defilement. Just 3 words. I was asked a question in the morning, so I'm giving an answer. I'm narrowing down on custom and usage, right? I was asked, why should we get rid of all custom and usage? Okay, I'm saying, all right, don't get rid of all custom and usage. Get rid of what this court has called egregious violations. This court said it in the judgments, and they agreed. The review petitioners agree that you can nullify an egregious custom, right? That answers my lady's question. Are we going to invalidate all customs? No, please don't invalidate all customs. Again, you will go from custom to custom. Again, a fact situation. But if you come across a custom which is either egregious or if it's based on notions of purity, pollution, and defilement, it's covered by 17. This is my argument. And I will prove it with reference to drafting history. I will also prove it, well, just by way of historical information. I'm going very fast because I want to finish and give others an opportunity. Just by way of history, the movement for temple entry started in Kerala. Another irony of this case. This case came from Kerala. But the temple for movement entry started in Kerala. Actually, it wasn't even for temple entry, it was for walking on the streets surrounding the temple. There is a report commissioned by the Raj Pramukh of Travancore, which is on the record. I have filed it. A full report. He appointed a group of experts and theologians to give him a report on what is the status of entry into temples in the state of Kerala. That report is on the record. It's been filed in your compilation. That report came to the conclusion that SC people were not allowed to walk around the roads. I was amazed at a submission made by Dr. Singhvi when he said, what is the meaning of temple entries? Inside the compound and stay there. That's what he said. Okay. Now, if you go to the history of Travancore, this report tells you that they were, why is 15.2 there? Because they were not allowed to walk along public roads if it was within the precincts of a temple. You had to keep away a certain number of kilometers. Okay. Secondly, Hindu law is not Hindu law of religion. It is Hindu law of religious and charitable endowments. Why? Because Hinduism considers charity as part of religion. They say do charity. He mentioned it. Mr. Dhawan mentioned it. He said it consists of two things. One is benefit in the other world, one is benefit in this world. You will get benefit in this world if you do charity. Okay? So charity was very much part of Hinduism. Do charity in this world if you want benefit in this world. Do sacrifice if you want benefit in the other world. That is why the core of Hinduism consists of sacrifice and charity. These are the two things. And that is why the law treats both charities and religious endowments together. If you read the entry in the concurrent list, it is one common entry for religious and charitable institutions because the two go together. And he explained that. And I'm sure, Milon, I'm not so familiar. I did read Faizi. I got a first class in my law, but I'm not so familiar with Faizi. But I used Faizi as my Bible to understand what is, till today, it is considered the best book on the subject of Muslim law. So there also, there is the question of charity. So just by way of, so 17 is, my page 18 is basically saying, what is the parity between scheduled castes and women who are considered polluted and defiling? And in my learned friend actually pointed out to me, he has given me a briefing note in which he pointed out initially the Indian Penal Code in the offenses under religion used the word defiling. Today it's not there, but it was there initially, defiling. Brings in the whole concept of sacrilege and blasphemy. But in our criminal law, we don't have the concept of sacrilege and blasphemy. For a good reason, because we don't have we don't have a constitution based on religion. Let me rush through it. No, the purpose of this is only to tell you that there's a parity between them, and this parity is recorded in the commission report in Travancore. After that, they say women in menses cannot enter. So here's my submission. In answer to the question of custom and usage, if a custom and usage is egregious, you will invalidate it as being violative of the Constitution of India. All right, don't invalidate all. I already said, I can't formulate it better than the Chief Justice. He told Arvind Datar that your submission is, if it's a harmless custom, if it is a custom which is not violating anything, we are not interested in voiding it. So again, you go. So now I'll just go through this, all forms. Article 17 has been interpreted as prohibiting any untouchability between, based on notions of pollution and purity, where they are found. Untouchability is a species of discrimination. What is it? The conceptual basis for excluding Dalits and women of menstruating age, or you take it age 10 to 50, are the same, namely pollution, impurity, and defilement. Defilement, and I told you, Bindu, after she entered, they did a shuddhikaran. She's about 40, she must have been 40 years of age when she went. But they did a shuddhikaran. I filed a petition in this court, and there's an order of this court giving me protection, police protection. But I never went again. That was the end of the story. She didn't have the courage to go second time. Wherever they are found.
Had she gone earlier?
Yes, her mother took her at the age of 11 and her father used to take her.
Then what did she do between 11 and 41? Why did she not go?
She was, one minute she was studying. She became a lawyer. She became a teacher in a law school. She started teaching. And after the judgment, She went.
Suddenly she woke up with the, when this writ.
We all wake up with judgments of the court, my lord, nothing new about it.
Is she a devotee?
1 minute, 1 minute, I want
Is she a
to.
devotee?
Can I answer that question a little later? I will answer it.
It's a difficult question.
I will answer it. But I can tell you she didn't go. She went. If I give you an answer saying she went to introspect, will you be satisfied with it? I'm
Definitely
telling
not.
you,
Definitely not.
introspection is the heart of religion. Please. It is the heart of religion.
Somebody who had not bothered to go is not
No,
a
just-
devotee, goes only after to
Just
prove that
1
the
minute.
judgment is right.
Am I right in saying that all of religion is about introspection, the eternal question, who am I, who am I, who am I? That is introspection. You will not get an answer to that question unless you sit at home and introspect.
We respect introspection.
Yes.
But it is not something which comes only one day.
No, it doesn't.
It's a constant for human conscience.
Yes, yes. If I say she went as an act of conscience, will that be a sufficient answer? I'll come back to that question at some point. I know that I have to answer it. But for the moment, I want to focus on 17. Okay. So the conceptual basis for excluding them is the same. Pollution, purity, defilement. So any custom which is based on pollution, purity, defilements has to go on the basis of 17. Show me any custom which is based on these issues, it will go under 17. Whether it's man, woman, child, animal, anybody. They, of course, the Shastras also tell you animals are defiling. They don't allow animals to enter temples.
Restraint. See, when there is, amongst Hindus, when there is a birth in the family, when there is a death,
Yes,
those days they don't go. Why? They are all restraints.
yes.
Only for the respect and you see, respect for the God.
I
and the
did
God.
agree.
It is a respect. It is a restraint.
That is why.
Somebody tomorrow will file a petition.
1 second, 1 second.
So there is a
I
birth
just
in
want
my
to tell
family.
you that,
Next day I will go to the temple.
your ladyship,
Or even though there is a death in the family, the very next day, though I am doing the, what is that, kriya karmas of the, after the death, I will
Yes.
still go to the, see, they are all restraints.
You're right. Your ladyship is right. They are restraints you put on yourself.
Yes.
Okay. Am I right in saying these are restraints we put on ourselves? All right. There is a provision in Hindu law which says birth is also defiling. A woman who gives birth doesn't go to the temple until the child is old enough to be fed. That is why in Sabarimala, women at the rice feeding ceremony go to Sabarimala. Okay. Though they are between the age of 10 and 20. 10 and 50. They are allowed to go. Even the other side will tell you that.
No, we don't.
No.
They are. The Tantri filed an affidavit saying they are allowed.
They are appearing for the visit, so
They don't.
Well, the Tantri filed an affidavit in which he said they are allowed to go. Raja took his wife for the first rice feeding ceremony to Sabarimala in Travancore. So what are we saying? Only Rajas can go, anyone else can't go.
Well, it is already on record in the judgment of the S. Mahendra that there was a rice feeding ceremony. Therefore, a letter petition was filed by some devotee that this is just
Right feeding ceremony.
There is a judgment, my lord.
Even it doesn't make any difference to them.
Coming back to the question of the birth death, even during death, they stay away. They say, I'm aware of those ceremonies. They have been followed in my own home. Let me tell you very clearly. So I'm aware of them. Okay. So you stay away. Okay. I have no problem with voluntary staying away at all. Okay. What you are doing is you're saying for the entire period of age 10.
To 50 also.
Yes.
The true devotees who are women between 10 to 50, they also observe this restraint and stay away. After 50, they will go.
Yeah, yes, there are many women in Kerala who say, why should I go between the age of 10 and 50? I will wait till I attain the age of 50. Then there are many. But there are also women who say, why should I not go between the age of 10 and 50? You have to deal with both of them.
Question
They are
is
not
whether
committing a crime. They are not committing a crime by saying, I want to go.
whether they are understanding the philosophy of that God or not.
It's talked about in this courtroom for 10 days. Yes, we are aware of it. I have read it in the Shastras, but I told you, your ladyship, I told you it operates in my personal house. I was not allowed to touch my mother during these periods. As you know, they're not even allowed to go to the funeral pyre. As you know, they're not allowed to carry the funeral pyre. We know all these things, but the question is it right or wrong? And if somebody's, I went for both my parents, that custom is gone. It's gone through actual practice. In my family, every single daughter of the family attended the funeral of her father and her mother. No one stopped us. No tantri stopped us. No organization stopped us. No dinner. It took place in the Arya Samaj premises. We went. No priest said, "Why are you here?" We carried our parents on our shoulders. We did. That is gone. That women can't do it. So, all right, these are changes, but we are talking about what is the basis. The basis is I'm polluted. I'm polluted during the period 10 to 50. I'm defiling if I go in. How can you take the whole expanse of my life? 10 to 50, after 50, 60 judges retire, 62 judges retire. What is,
Why do you
chunk of your life is gone.
Why do you perceive it in the form of pollution or defilement?
Because it is
Don't
written
perceive-
in the Shastras.
Don't perceive it in that form. Don't perceive it in that
Very
form.
good. I'll leave it at that. I have taken it from the Shastras. It is written there. I've annexed it. I will read that annexure. And I've filed the. What did the Maharaja of Travancore do after he received this report? He issued a proclamation saying everyone is entitled to enter. And let me tell you, your Lordship remembers that Mr. Manu Pillai delivered a lecture on the same platform as you. Okay, he's really an expert on issues. He's written a book called Gods, Demons, and Guns. And he said, I asked him after the lecture, I said, what was the basis of Travancore Cushion not allowing? No, why did the Raja issue the proclamation? He issued a proclamation saying all people can enter. You know the answer I got? The answer I got is because if we don't allow them, they will all convert to other religions. That is also very much there. It is very much there in the mind of lawmakers. You read the proclamation, I have printed it out for you. You read it. They threw it open. Why does the Constitution use the word throwing open? Because the doors were closed.
Madam, one thing in your favor, which may probably may be an argument from your side, is that the restriction from 10 to 50 can also be seen in the nature of a permanent disability, for nobody knows how much life he has got. Very next moment. So for all practical purposes, you cannot say that I will attain the age of 50 and then I go. For all practical purposes, what matters to me is today.
Yes.
Present matters to me.
And this
I'm not very.
Constitution matters to me today.
That's one point I thought I should tell you. Maybe you could.
So, Milan, I'll quickly finish the drafting history.
Yes.
The only purpose of putting this drafting history on record is to show you that an amendment was moved. Somebody raised the question that this will include women also. Therefore, confine it on the basis of religion. Amendment was and members said no. We cannot today anticipate what are the forms of untouchability that we will see in the future. And I said, leave it as in all forms. That's all. I will not trouble you. I'm sure you will read it on your own. And in the annexure, I will just show you which is the annexure, but I don't really need to say it because your ladyship and all of you know this better than me.
Madam, where is that? The amendment mode, where is it?
That amendment, I will point out.
Page 2.
Just point out the amendment which will.
You're referring to
Page-
Annexure D?
No, annexure B is the extract from the Travancore.
D. No.
Yes, the Raj Pramukh's report is there.
This-
But the amendment,
Page
page 20.
20.
This was the amendment. Sir, I move that for Article 11, which is 17, the following article is substituted. No one shall on account of his religion or caste be treated or regarded as untouchable, and its observations in any form may be made punishable by law. Rejected.
The amendment was negative.
Next is the
And
You may
there was a reference to women.
You may read page 22, K.T. Shah's
Yes,
on this.
I'll read it.
That is
At the top of the page, Malone. Yes. Mr. Vice President, sir.
Here.
No, the second.
The second one, all right. K.T. Shah, in the first place, I would like to point out that the term untouchability is nowhere defined. The Constitution lacks very much the definition clause, and consequently, we are at a great loss to understand what is meant by a given clause and how it was going to be given effect to. You follow up the general proposition about abolishing untouchability by saying that it will be in any form an offense. And that's why the government had to frame a law, an offense, and will be punished as at law. Now I want to give the House some instances of recognized and permitted untouchability, whereby particular communities or individuals are for a time. Now, this also answers the temporary untouchability.
Read it further.
Yeah, time placed under disability, which is actually untouchability. We all know that certain periods women are regarded as untouchables.
This is the line.
Yes, Vinod. In that, is that supposed to be? He was asking a rhetorical question. Are you telling me that they are also included? Therefore, make the amendment. They said, no, we won't make the amendment. It will be regarded as an offense. And why they rejected the amendment? Because they say we cannot anticipate what are the different forms under which we will find untouchability in this country. I'm speaking from memory, but I believe I'm right that the Quran in certain surahs that is mentioned specifically and categorically, will you make the practice of their religions by the followers of that religion? There's an error there, punishable offense. Again, there are many ceremonies in connection with funerals and obsequies. Same thing. At this period, we are not supposed to go anywhere near a temple, which make those who have taken part in them untouchables for a while. This is Hindu law treated these as temporary untouchability.
It's not really an untouchability. It is some kind of not even a disability.
I'm going to.
The persons themselves don't think
Yeah.
that it is untouchability or it's a disability.
I'm going to go a little faster, but I will read to you what Vivekananda said about this. I will read it. This, of course, after the Constitution. I will read it. I've annexed it, actually. I do not wish to inflict a lecture upon the House on anthropological or connected matters, but I would like to be brought to the notice that the lack of any definition of term makes it open for busybodies and lawyers. Maybe I'm one of those.
But this is exactly what was Mr. Shah's apprehension.
Yes, it was.
And since there is no definition of untouchability,
Yes.
even the disqualification for women of a certain age will be defined within the definition of untouchability.
Yes.
You read that, madam,
And-
busybodies and lawyers to make capital out of a class like this.
Capital or lack, capital is a moot question. Capital or lack of capital is a moot question, my lord. But I am actually very proud to say, and it's recorded in the judgment of the 3 judges who referred the matter to 5 judges, that I raised it at the earliest possible opportunity. I said it. I said, according to me, this is the form. I can't repeat again and again whether my submissions are acceptable or not. I cannot say. But my perception, this is my perception. I know how I feel when I'm not allowed to enter. I know my feelings. I know when I was not allowed to touch my mother, I knew what I felt. In my family, I was not allowed to touch my mother for 1 week. She was not allowed to eat on the table with us. Anyway, it's gone. It's part of history, so I don't want to lament about it. It's over. That phase of my life is over. It reminds me of a very interesting question. Once I was arguing a matter in the Delhi High Court, and suddenly, my lord, the single judge sitting there asked me a question. Ms. Jaising, why aren't you a judge? He said. He asked me a question. I said, sir, don't worry, I've gone past the age. So no one is going to ask me these questions anymore. So don't ask that question. So, my lord, it is. And then if you see, I cannot accept the amendment. And it stands rejected. I leave article. Then now, if you see the dissenting judgment of Sinha on the question of social ostracism, he is invoking 70 at page 24. Oh, dissenting judgment.
In Sayadna.
Yes, but it's a dissent. Page 24, no? 25, middle of the page.
He upheld the tax.
On the social aspect of it.
On the social aspect of excommunication, one is inclined to think that the position of an excommunicated person becomes that of an untouchable in his community. And if that is so, the act in declaring such practices to be void has only carried out the strict injunction of Article 17 of the Constitution, by which untouchability has been abolished. Just to give you an idea, now, my Lord, there's one very important judgment I want to read. I will just continue. Adityam, judgment of this court, 2 judges. Let me read it. Have you got extracts here? No, extra, they call Hindu religion revolutionary. Why? Because it reinvents itself. This is 2002, 8 SCC 106. The case concerned the appointment of a Brahmin as a non-Brahmin as a priest. I was asked this question. This question has arisen in 2 contexts. In the context of whether a non-Brahmin can be appointed a priest, 3 judgments cover the field. And the answer is less, that this is the 3rd one. Now, please read relevant passage. Where is the relevant passage? At page 122. No, the revolutionary. Okay, para 18. Para 18 at
Para
page
16.
124.
You've quoted at para 16, page 26.
I have in the submission.
Yes, in the submissions, you started its vision of the following founding fathers, and then you quote para 16.
Yes, para 16. But please turn to para 18 in the SCC, which is displayed on the board. In the present case, it is on record, and to which we have also made specific reference in the details of facts showing that an institution has been started to impart training of students joining the institutions in all relevant Vedic texts, rites, religious observations, and modes of worship by engaging reputed scholars and tantris, and students who ultimately pass through the test are being initiated by performing the investiture of sacred thread and Gayatri. That apart, even among such qualified persons, selection based on merit are made by the committee, which includes, among other, schools of reputed tantri, who also, and the quality of the, evaluates the quality of the candidate. Then come down the page, the decision in Sururmat and the subsequent decisions referred to by this court had to deal with the broad principle of law and the scope of the scheme of rights guaranteed under Article 25 and 26 of the Constitution in the peculiar context of the issues raised therein, the invalidation of provisions empowering the commissioner and the subordinates, as well as persons authorized by him to enter into religious institutions or places of worship in any unregulated manner, or even persons who are not concerned with the spiritual functions as being considered to violate the rights accrued under 25 and 26 of the Constitution of India, cannot help the appellant to contend that even persons duly qualified can be prohibited on the ground that such person is not a Brahmin by birth and pedigree. None of the earlier decisions rendered before Sheshamal related to considerations of any rights based on caste origin. And even Sheshamal case dealt only with the fact of rights claimed on the basis of hereditary succession. The attempted exercise by the learned senior counsel, who was the learned senior? Never mind. No, let's not mention names. A senior counsel. None of the earlier decisions referred to dealt with only the facet of rights claimed on the basis of hereditary succession. The attempted exercise by the learned senior counsel for the appellant to read into the decisions. This is what has been happening in the last 10 days. My learned friends have been reading into Cyril what does not exist over there. Read what they're saying. The attempted exercise by the learned senior counsel for the appellant to read into the decision of the court in Shururmat, the other something more than what is actually purported to lay down as if they lend support to assist the and protect
Sorry, don't put.
any and everything claimed. Any and everything claimed. As being part of religious rituals, rites, observances, and methods of worship, and make such claims immutable from any restriction or regulation based on the other provisions of the Constitution or the law created to implement the constitutional mandate, deserve only to be rejected to merely a superficial approach by purporting to decide what otherwise has really an overriding effect in the scheme of the rights declared and guaranteed under Part 3 of the Constitution of India. Any custom or usage, irrespective of even any proof of its existence in pre-constitutional days, cannot be countenanced as a source of law. This is the issue. When you say force of law, it means source of law. As a source of law, to claim any right when it is found to violate human rights, dignity, social equality, and the specific mandate of the Constitution and the law made by Parliament. No usage which is found to be pernicious. Now, this is not for the first time that the word pernicious coming here. They called it egregious and considered to be in derogation of the law of the land or opposed to public policy or social decency can be accepted or upheld by the courts of law. The question is upholding by a court of law. Where's the revolution part? They said it's Hinduism is revolutionary.
122, middle of page 122.
Middle of page 122, quoting B.K. Mukherjee. Para 29. In the Tagore Law Lectures on Hindu Law, Religious and Charitable Trusts, the popular Hindu religion of modern times is not the same as the religion of the Vedas, though the latter are still held to be the ultimate source of authority of all that is held sacred by the Hindus. In the course of its development, the Hindu religion did undergo several changes, which reacted on the social system and introduced corresponding changes in the social and religious institutions. But whatever changes were brought about by time, and it cannot be disputed that they were sometimes of a revolutionary character, the fundamental moral and religious ideas of Hindus, which lie at the root of their religion and charitable institutions, remain substantially the same. And the system that we see around us can be said to be evolutionary product of the spirit and genius of the people passing through difficult phases of their cultural development. This is it. This is what 25(2)B is about. And that's why I said it's internal to religion. I'm not asking you to invent a test of essential, non-essential. Religion itself tells you what is essential and non-essential. So that finishes my submission on 17. There is the extract from the Travancore report is annexed, where they say women and avarnas were treated the same during the period of, they call it menses. Okay. Now, my lord, I think I've almost finished because the rest is a matter of statutes. As I said, the good news is that all states have enacted temple entry laws. So I don't really have to come and argue this case. I can rely on my statutory right. And those laws have been immunized from constitutional challenge. That is what 25(2)B does. It immunizes temple entry laws from any challenge. That's why they're put in the Constitution. You can't, unless you amend the Constitution by a 2/3 majority, it's not just a statutory right. That was my reason for saying it's not just a statutory right. It becomes a fundamental right, which cannot be taken away by a legislature. Also, the legislature can enact a law in order to give effect to it, but they can't take it away. That is the submission. Now, my lord, the rest is about how Warren Hastings, just read that proclamation, which is at the end of 28. This is now on the question of judicial review, since you have framed a question. But I have addressed it substantially by saying, please don't tolerate any attack on judicial review. Please don't say that we are not able to decide a question of religion. You are able to decide it. Now, as far back as in 1772, it was Warren Hastings who issued a proclamation who said, in all suits relating to inheritance, marriage, caste, and other religious usage or institutions, the laws of the Quran with respect to Mohammedans and those of Shastras with respect to Jantus, Hindus, will be invariably adhered to. Meaning what? They have the force of law. So all your customs and usages have the force of law. That was the reason for putting 13(3)(a) into the Constitution. It says it's for the purposes of Chapter 3. Much was said that, all right, take the definition from 366. Somebody else said, take the definition from 372. No, for the purpose of 273, for part 3, you will take 13.
Drafting history.
Yeah. Now, there is a very interesting drafting history of 13 where all these questions were. Lord, I feel that I should ask you to read this rather than my laboring the point over here. But what I want to tell you is that the drafting history of Article 13 indicates that it was meant to target non-state actors. Custom and usage is not made by the state. Custom and usage is made by people. So the question is whether that then in the debates, which I have not given you a full text, I will provide you with a briefing note if you wish, but I have put it down there very clearly that the purpose of 13(3)(a) was to invalidate custom and usage which had the force of law. So the question was discussed. What do we mean by have the force of law? And when we say have the force of law, the answer was which a court of law will enforce. And every one of these practices was enforced by the court. I've given you a list of judgments which emanate from the Privy Council down till today, where these customs were enforced. So it has a force of law. That was my argument in the Saira Banu case. When I was asked a question, Ms. Jaising, how can you invalidate a custom? Are you relying on 13(3)(a)? But that was an easier case to argue. That is why Justice Nariman refers to it. He refers to Narasu Appu, but he says, in this case, I do not have to overrule it. Mind you, my lord, Narasu Appu is a judgment of the High Court. It's not a judgment of the Supreme Court. But no court has overruled it. I have been coming to court again and again, and that is why Justice Chandrachud has footnoted an article written by me in which I said the ghost of Narasu Appu is stalking the Supreme Court of India till today. You have not been able to get rid of Narasu Appu. And I remember when I said it, Justice Kurian Joseph told me, Ms. Jaising, now is the time when we can exorcise that ghost of Narasu Appu.
What is the reference of that, Narsuapu?
If the reference of Narasu Appu, it is in this also. It is in Sabarimala also. It is referred. I'll give the reference, my lord. It's Justice Gajendra Gadkar and Justice Chawla. Chagla.
But Justice Chandrachud doesn't approve of what Justice Gajendra Gadkar said in Appu.
There are at least 3 very well-known scholars who did not agree. One was Justice Chandrachud. He deals with it in Sabarimala. Secondly, Sirvai has written in his commentary, I don't agree with the judgment. Thirdly, there was Justice Bhattacharya, my lord might know that. He was transferred to Bombay and became Chief Justice. He has 2 seminal books, one on Hindu law, one on Mohammedan law. in those books also he has criticized Narsu Appu and he says, no, this is not good law. But Narsu Appu is a judgment of the High Court. It's not a judgment of the Supreme Court. And I have a detailed memorandum on that, which I can file later, why it's wrong. But for the present moment, it suffices to say that when Justice Nariman asked me the question, on what basis are you asking us to invalidate triple talaq? My answer was this: recognition by the court. Tell me whether the court is recognizing triple talaq or not. If the answer is yes, then you can strike it down because it has the force of law. It is a source of law if it is implemented by a court. And triple talaq was being implemented by the courts as law. Only then he gave a judgment in which he said this is manifestly arbitrary. But he did not overrule Narsu Appu. He said, let that be done on some other occasion. Twice he has made an observation to that effect in two different judgments. Even in Sabarimala, there is that observation. We will leave it to another day. But Justice Chandrachud addressed it directly and said, I don't agree with these judgments. So I come back, I leave it because I've already dealt with 20. Too many people have dealt with it. So I need not deal with it all over again. I will only take you to the end. Well, there's one judgment.
One thing, other important is that what will come as under the garb of religion and secular. Where we can, either test.
I have given a chart which is annexed to my written submissions. What are the rulings of this court? I can't go beyond the rulings of this court. I'm simply saying I agree with all those rulings. What the court has, there's a long line of judgments where the court has said this is secular, this is secular, this is secular. It's all there. I've put that case law in an annex chart. That's the citations. Please take it as good law. As far as I'm concerned, I'm not disputing that it is, but I will. Yeah, you got the Narsu Appu citation.
This is in volume 5.7.
Just give the citation.
51 SSC online.
It's a 1951 SSC online Bombay at page 7. It's not a judgment of the Supreme Court. To this extent, the court has been unwilling even to invalidate statutory law. I told you section 6 of the Hindu Marriage Act. Go read that judgment below. They do not declare it unconstitutional. Anyway, it's an old story. Why raise it up again? Well, there's one judgment which no one has referred to, and that is on the record of the court. Sri Krishna Singh versus Mathura Ahir, 1981, 3 SCC. This may give you the answer. I'm not sure, but it may give you the answer to the question why denominator. 1981, 3 SCC, 689. From page 1 to page, how many pages is it? The entire judgment deals with what is a sampradaya, because an attempt was made to say that don't use the word denomination, use the word sampradaya. The whole judgment is quite an amazing judgment, which must be using the word sampradaya at least 100 times in this judgment.
Can you repeat that citation now?
Yes, my lord. The citation is 1981 3 SCC 689.
The combination also.
And in your lordship's compilation,
5.7.
it is in volume 7,
5.7.
5.7,
Then the
item 10. It's there in the compilation, but it's being displayed over here. If you read this judgment, it's too lengthy for me to read from cover to cover. But the entire question in this issue was, what is a sampradaya? What is a denomination? And as I said, the word sampradaya may have been used in this judgment at least 100 times. It's a judgment authored by A.P. Sen. And my lord, it is relying on this judgment that I make those two submissions, that to the denomination add two more issues. Doctrinal is there, organization is there, name is there, but we need to add to it. There is a living guru in mutts, and only mutts have been given denominational status. This judgment mentions that there are living gurus in mutts. And secondly, this judgment also talks about how denominations are a form of protest. They tell you what is a mutt. They tell you it is a place of learning. They tell you it is a place where, since the time of Shankaracharya, mutts have been established for the purpose of giving theological education to people. And because Mr. Giri used the word guru, he said, my guru tells me. I wanted at that time to ask him the question, who is the living guru in Sabarimala? Is there one? There's none. There's a deity. But there's no living guru to my knowledge. But he did say that I follow the dictates of my guru. We all follow the dictates of our gurus. We are not immune from that. But then we have a living guru or a denomination to which we belong, which has a doctrinal a way of teaching us what is theology. So this is the judgment which tells you what is a mutt in para 19. Then in para 21, it tells you what is the denomination. They call it a cult or religious fraternity. The word fraternity is used. It's a fraternity. Well, I will. Well, just give me a few more minutes. I don't want to carry it over. Let others have an opportunity. Just give me a few more minutes. This is really the last judgment I wanted to cite. And then if you turn the page, there is a reference to the fact that it's a form of protest against certain forms of orthodoxy. And that is why I said, if you see the history of Hinduism, it is a history of reform movements. No, yes, para 46. It says, Hindu asceticism represented further a revolt from, or at least a protest against the tyranny of caste. In its origin, probably remote from Brahmanism and conveying the ordinary idea that bodily pain was profitable for the advancement and purification of the spirit, the ascetic life became in association with Hinduism and under the prescriptive sanction of Hindu law itself, a refuge from the burden of caste rules and ostracization. I'll leave it at that. If you go through the whole judgment, you will probably find a lot of enlightenment about what is. Of course, I resist the use of the term sampradaya because the Constitution says that English is the language of the Supreme Court of India. So if you have to give me that article, please. So if you have to interpret, you must interpret the word denomination. You cannot interpret the word what is a sampradaya, but you may be aware what is a sampradaya. Now I'll just quickly turn you to the next.
Madam, let us be very clear. The Supreme Court language is English, but we are interpreting the Constitution. So that the language is Hindi. So there's no.
Hindi is the official language of the Union, but English is the
Constitution also. It is the
Supreme
version
Court
which
says
prevails.
English. Supreme Court it is English.
Supreme Court language is English, but for interpreting a document, that document, the English version will prevail over the English version. That's in the Constitution itself. There's you can't say that.
Yes, not English version prevails.
English version will not prevail.
Yes, so you can't get away from deciding what is the denomination. That's all I'm saying. You can't say they are interchangeable. They are not interchangeable. Not, I'll just only take you to the annexures. I won't read them. I will only, what I have given here is what are the pre and post constitutional laws governing temple entry? What are the pre and post constitutional laws governing religious endowments? Please link it with the concurrent pass. Even to change personal law, it's in the concurrent list, entry 6. Similarly, religion and charitable endowments is in the concurrent list. So all these laws, every state has made endowment laws, laws to regulate endowment. It all came from mismanagement. Your ladyship said manage doesn't include mismanage. That's the origin of all these laws. Because the Rajas endowed millions and millions of acres of land to temples. That was a religious practice to endow land to idols and to temples. So they are sitting on acres of land. And that's why it became necessary. Tomorrow, if you agree with their suggestion, there's nothing to prevent them from selling off that land and building a shop or what do you call it? Anything else. Today, it is fixed for religious purposes and for charity. That is why almost every state has passed an endowment law. And every temple in the country is covered by an endowment act. And all of them have come to the Supreme Court challenging it, and the Supreme Court has upheld some of those laws. It has struck down certain sections of those laws, which is fair enough. Lord, I'm not disputing. In short, I'm not disputing any case decided by the Supreme Court till today. I'm only saying no case has been made out to depart. They're asking you to depart from 2 centuries of law. That's the claim being made over here. And in any case, they want you to depart from 75 years of constitutional Supreme Court history. When was Shirur decided in 1951? Holding the field till today. So you are going to undo things which have been done over these years. People have relied on it and altered their status depending on these laws. So, not just the annexures, the first annexure, your ladyship will just look at the drafting history. I'm not reading it. The drafting history of Article 13 will indicate who moved which amendment and why. It was introduced by B.N. Rao, custom of usage. And Dr. Ambedkar introduced having the force of law. It shows his legal jurisprudential expertise. He said, no, not every custom, but every custom having the force of law. So that is the touchstone. That is the first annex. The second one is, yes, it's an appropriate way to end these proceedings. I've given you a list of cases, what the court has done in such court. But Milord, the most appropriate way, I'm going to end over here by telling you what Swami Vivekananda would have thought about these proceedings. He's put it in writing. He delivered a speech in Kerala. That is why there is a statue of Swami Vivekananda on there. It's at annexure 78. I will just read it. These are his words. He is considered the greatest reformist of Hindu law. He said, think of what the last 600 or 700 years of degradation, when grown-up men and by hundreds have been discussing for years whether we should drink a glass of water from the right hand or the left hand, whether the hand should be washed 3 times a day or 4 times a day, whether we should gargle 5 times or 6 times. What can you expect from men who pass their lives in discussing such momentous questions as they are writing most learned philosophies on them? There is a danger of our religion getting into the kitchen. We are neither Vedantists nor, most of us now, nor Puranics, nor Tantris. We are just don't touch meists. Our religion is in the kitchen. Our God is in the cooking pot. And our religion is don't touch me, I'm holy. If this goes on for another century, even one of us will be in a lunatic asylum. It is a sure sign of softening of the brain when the mind cannot grasp the higher problems of life. This is what our lady has been telling me, that what is it that we are talking about? We are talking about me and my conscience. I am asking the question, who am I? And unless I get the answer, I will continue to go to temples. The day I get an answer, I won't go to the temple. I go there looking for that. I was asked the question, why introspection? What is introspection? Religion is an offshoot of introspection. If this goes on for another century, every one of us will be it is a sure sign of the suffering of the brain when the mind cannot grasp the higher problems of life. All originality is lost. The mind has lost all its strength, its activity, and its power of thought, and just tries to go round and round in the smallest caves it can find, curves it can find. Lord, I thank you. There's only one supreme irony which I would like to mention to you. Who was Shabri? All of you have read the Ramayana. She was a woman. And what did she do? She offered a maid to Lord Ram. She said, the myth says that I have been waiting all my life to meet Lord Ram. It was my desire, my inner desire. Then I heard that he's coming to Sabarimala. What was Sabarimala? What Malay means, a hill. Who lives on hills? Tribals live on hills. This is their original home. My learned friend here told you that there are people who believe it's a tribal deity. Never mind about what they believe. But go back to Shabri. She was a woman. And she said, finally, my dream is coming true. I will meet Lord Ram. Then she said, what will I offer him? I've got no money. So she said, I'll offer bed to him. Then she said, what if the bed which I offer him is bitter? It won't be an offering. Then she said, let me taste it. I will discard the ones which are not sweet, and I will only keep the sweet for him. Now when Lord Ram came, she offered him those beds. His brother Lakshman said, what are you doing? You can't do this. He has eaten these. How can you eat it? And what was his reply? He said, I'm honoring her belief. I'm respecting her. She's doing this for me. It's an act of love. And this is the reason why I'll eat it. And that same Sabarimala, you're keeping me. I'm also a Shabri. You're keeping me out. That's the end of the story.
You continue,
But I'm-
but that Shabri was above 50.
Continue on Tuesday. Next Tuesday.